in item number 15, Lordship.
But you're mentioning for you, Sharma.
Lordship.
You're mentioning for the respondent,
No, for a petitioner, Lordship.
M. Sharma.
M. Sharma, Lordship.
Okay, M. Sharma, learned counsel for the petitioner, is said to have some personal difficulty to conduct the case today. On a prayer made on his behalf and not objected to by the other side, matter stands adjourned. To be listed again. This is what, for hearing or for admission? State, on 14 September.
Much obliged, Lordship.
Here, please, the Lordship. Lordship, item number 6, adjourned to the day, Lordship. Consent from other side. Lordship.
You for the petitioner,
Yes, Lordship.
on the request made by the learned counsel for the petitioner, matter stands adjourned for the day.
Met please, your lordship. With consent of the other side, I beg to mention item number 35. Due to some personal difficulties, the conducting counsel is absent to remand.
You know, adjournment slip has been circulated on
circulated.
behalf of Mr. P. Bhardwaj, learned counsel for the petitioner. To the effect that he has some personal difficulty to conduct the matter today. State prayers not opposed to by the other side, accordingly matter stands adjourned. To be listed in the month of September. No, to be listed on, we'll give a date, we'll give. listed
Any date, my lord.
On 10th of September.
Obliged, my lord.
May I please, your lordship? I beg to mention for listing one writ petition in admission column, lordship. From Monday,
When was it last listed?
19/6/2026, lordship.
It'll come up on,
Yes, lordship.
17th of August, okay?
Deeply obliged.
May I please, your lordship? Because in this case, I have entered, I have filed the Kalatnama yesterday, Milord. The earlier conducting counsel has, written the brief, Milord. So I need some time in this case. I need some time, Milord.
What is your good name?
A Ali, Milord.
A. Ali.
A Ali.
The others will not appear now.
Yes, Milord, because I have filed just yesterday, Milord.
You have an NOC.
Milord, no, my lord, actually, I have been instructed that NOC has been given, Milord, and that the file is already with the, party. So NOC has been taken, Milord. Because the earlier counsel has already joined as the official, Milord, public prosecutor, Milord. Therefore, he returned the brief, Milord.
So when do you want it?
Milord, I need some time, Milord, because I have not.
Yes,
Lordship, I appear for the department.
Mr. A. Ali, learned counsel, submits that he is the newly engaged counsel. And therefore he needs some time to prepare the matter. But he also submits that the earlier counsel has since been appointed as a public prosecutor and he has returned the brief and also given his NOC.
My lord.
Mr.
G Bordello.
G. Bordello, learned counsel, appears for the
4% department.
Foreign department and has no objection. The prayer for time. To give above, release the matter. 7th of September,
My lord. Obliged, me.
that's grateful. None appear for the parties.
Shall I appear for the respondent board in item 22, Your Honor? He is retired in the year 2024 itself, Your Honor.
Your client is retired.
In the year 2024 itself, Your Honor, as the Chief Secretary of Government of Assam, Your Honor.
So before his retirement, what is the status?
So if your Lordship goes through the FFT part of the order,
Yes,
paragraph number 19
age,
must be 66, Your Lordship. Paragraph 19 of the order, Your Honor.
'66.
66 of the consent petition. Paragraph 19 of the order.
Okay, you're talking about item number
22, Your Honor.
22.
Correct, Your Honor.
Give me 22. This is 21.
Order will be common, Your Honor, common order.
Paragraph 19.
19, Your Lordship.
Area honorarium.
Yeah, directly pay the area honorarium to the female attendants minimum is 95 from the date of engagement to 30th of September 2010. I am allowed to place an order of 2024, Your Lordship, 2nd January.
Yes, what is this?
Your Lordship, here is the lot. Later I have provided, Your Lordship. They have taken the decision to approve a minimum wage of 900 per month from July 1988 or from the date of engagement, whichever is later, until 30th of 9, 2010, as specified in the order, Your Lordship. After processing the matter, Finance Department has requested the department submit the following information.
This is from the health department.
Yes, Your Lordship. To the office of the then Chief Secretary.
Hmm.
It's a letter of 2nd of January 2024.
You have a copy of the letter?
Yes, second.
No, what does it say? To the secretary, coordination to the chief secretary.
It's a secretary, secretary to the Chief Secretary's office, Your Lordship.
This is how it is addressed.
Yes, Your Lordship.
The secretary, then coordination,
Even some of my communication is addressed from that office itself. Yes,
coordination to the chief
yes,
secretary.
secretary to the coordination to the Chief Secretary Assam.
You represent respondent number
2,
two. Who is two?
then Chief Secretary of Government of Assam, Your Lordship.
So what did you do then?
Then, Your Lordship, I
Huh?
am not in the position to provide the information because by March, 31st of March 2024, the president of the Chief Secretary retired, Your Lordship. So they need to implement the present Chief Secretary.
31st of March
2024.
2024. No, this letter has come to you on January.
Yes, Your Lordship.
So what did you do to the letter?
It was not provided to me in the month of January, Your Lordship.
It is not that you have written the letter.
No.
It is the letter which is addressed to you in January.
Yes, Your Lordship.
So what was the further course of action?
My lord,
There is another letter of 24th of August 2023, Your Lordship. I'm allowed to provide it.
But didn't you file a show cause reply?
Pardon, Lord.
Didn't you file a show cause reply? Once a contempt is filed, what are you supposed to do? Give papers by papers like that?
No,
Then This is not proper, you see. You're asking me to read all those papers, loose papers you're supplying. Why don't you file an affidavit?
Their officer retired already in 2024.
He's retired from, not from this world. He's retired from his office.
Yes, Lord.
He's included as by name, by person,
Yes, Lord.
correct?
Yes, Lord.
So you have to file. Just because he retired doesn't mean that he is. The thing has gone from his
But now
responsibility is gone.
filing the position of the chief secretary, Lord.
Maybe, but whatever he knows, whatever he did during his service time, he should reflect that in the affidavit.
Because later is to the health, your lordship, that present data has to be placed before lordship by the council for the health department of finance, your lordship.
You file your affidavit, whatever it may be.
There are other officers, they might have the present status, your lordship.
We will call from them. Don't worry about that. But whatever you have done in during your service time, you have to tell us. By way of an affidavit. Yes, Mr. Counsel, what do you want to say?
My lord, this is, my lord, despite my lord repeated direction of this honorable court lordship. You lordship, the honorable court, my lord.
What is the status? Tell me. Okay.
My lord,
You have
only,
brought,
my lord,
you have brought to the
out of
notice of,
4,000
just a minute.
Yes,
You have brought to the notice of the court that the court order has not been complied with.
yes, lordship.
Now I'm asking you, what steps have been taken pursuant to the notice? Any updates? Any
My lord.
updates? Have you been communicated by them?
My lord, to some extent, my lord, fresh contempt has been filed, lordship. My lord, only 1,600 has been paid, lordship. Out of more than 4,000, lordship. My lord, other contempt petitions are also, my lord, listed, lordship. The honorable court, my lord, in January 2000,
See, just a minute. These are three contempt petitions, correct?
lordship.
Three. It's a common order.
Yes, lordship.
Where does it start? Show me. I'm
My lord,
I'm holding item number 22.
My lord, 23, lordship, in item number 23, lordship, this honorable court's order, lordship, 23.
I told you I'm holding item number 22.
22.
Do you have 22 file?
Some of the this common order is lordship
Yes. What is the common order?
at page 33, lordship.
33.
Lordship. My lord, page,
WPC 900,
My lord,
1801,
yes, lordship. Paragraph 9.
172. Three cases.
My lord,
No,
many
4
cases,
cases.
lordship. One was filed by the, my lord, all Assam Female Attendants Association, lordship. My lord, paragraph 19, kindly see, lordship.
There are
Page
4,
66.
just a minute. There are 4 cases, correct?
Lordship.
You know how many cases
My lord, lordship, contempt case, lordship.
in the contempt in the order of the court in writ petition?
Read petitions, my lord. One was, my lord, all of some female attendants, my lord, many other cases, or my lord, all, not only 4 cases, lordship.
Which are your cases?
My lord, all of some female attendant association, lordship
Case number?
is 33. My lord, one, my lord, at page 35, lordship. Page 35, lordship.
Will adjourn
This
the
is my
matter.
lord- This association represents all, my lord, female attendants.
You're not ready.
Page 35, lordship.
No. We'll adjourn some other day. You prepare, come.
Lordship, this is the parties, petitioner is all Assam Health Centers, Female Attendants Association, lordship.
You can't even point out what is what. You're wasting my time.
So this is also our case, lordship. This covers all cases, lordship. All female attendants, lordship.
I know that.
Lordship.
We can see it covers all your case. But your case is 3 cases. And I'm asking which is,
My lord,
which
here
are,
the contempt case, lordship.
I'm asking you which are your cases?
Contempt cases, lordship. Contempt is all the 3 cases, lordship. Item number 22, lordship.
You
23
come to page 33.
Page 33, Lordship.
Annexure 2.
In item. Lordship. Annexure 2, Lordship.
Page 33.
Page 33, Lordship.
Top of the page.
900, WBC 900, Lordship.
Listen to me first.
Yes.
Top of the page, you will find how many case numbers? 1, 2, 3, 4, 5, 6, 7, 8. In all, 8 cases are there.
Lordship.
Please identify which are your cases.
My lord, WPC 900 of 2013, Lordship.
And
My lord, those are my other cases, my lord, were filed by individual, my lord, female attendants, Lordship. My lord, we are not on that, Lordship. Now,
then what is item 21 then?
item 21 also, Lordship.
Why you filed 3 contempt case then?
My lord, separate, my lord, the different time, in different time they came, Lordship.
No, 1 writ petition and 3
That
contempt
one
case.
will do, Lordship, but grievances of, my lord, of other female attendants, also, they will not pay, Lordship. That is why they came, Lordship, in common, Lordship.
Contempt case 303. 303. Item 21.
Lordship.
You are not the counsel?
That, in that case, Lordship,
Are you the counsel?
Lordship. 21, I was there, Lordship.
Please write. Since the counsel for the petitioner appears to be not prepared, list the matter again after 2 weeks. Respondent concerned. Respondent parties should file their show cause reply.
Well, so far as the respondents are concerned, madam, all are now either retired or they've been transferred out of the
I
department.
know, that's what your friend said, but
Yes.
they have to file.
I don't think. But they will have no instruction because they are not in the department.
No, whatever they have, whatever they know, they should file. And counsel for the petitioner will consider replacing them by new.
And one more thing, madam.
See,
they will
tomorrow,
have to
the
see-
present counsel, the present respondent will again say that, see, I am no more, I have resigned. He will implement fresh one. Fresh one also, again, one day he'll retire, said, I am no more the thing. How long will this go on?
But madam, Lordship will first see, madam, whether the service. has
Have
been
you filed any
completed.
show cause reply?
No, Lordship will kindly see, madam, whether the service has been completed or not, madam, on all the respondents.
Then why are you appearing then?
Well, in item, one item I am there,
You are appearing, that
Yes,
means
because-
you have the notice.
21 and my lord 23
That's 20 plus, no?
for particular respondent only, madam.
So that
Yes,
particular
for the
respondent,
I will, yes,
the particular respondent you represent, you file a show cause.
lost, that I will.
Whatever knowledge you have up till you demitted your office, you file that.
Lost it,
The rest will take care of it.
lost it.
And if
one
the
more
council
thing-
does not implement a fresh person, then we can't go
Yes,
ahead.
they will suffer. And one more thing, my lord, Bardwell limitation order, the order is of 2017. Contempt filed in,
You say that in your reply.
I will file it.
This trend I've seen, you see, you will not file any reply, but you will supply one copy of some order sheet, loose sheet, and say, this is what happened, this is what happened. This is, I don't appreciate all this, you see.
Lost,
Then file a proper reply saying that this is what has happened.
lost it.
This much I have done, but this, beyond this, I don't know, I am retired.
Yes, that's.
And on maintainability, you can also say that this is beyond
I
a
will
period of
raise the
one
issue.
year. It's not maintainable. We'll look into it.
Lost it.
Well, another contempt petition, Lordship, that is pending. May I pray for, my lord, listing along with this, my
Make it
lord?
3 weeks. Make it 3 weeks. List again up to 3 weeks.
My lord,
What another contempt?
my lord, 22 contempt, case 22 of 2025, Lordship. That is also pending, Lordship. My lord.
Pending money, it's connected with this case.
Yes, Lordship.
Common judgment.
Lordship.
You are the counsel?
Yes, Lordship. In that.
Then why you're mentioning today only?
My lord, it was
Why you're mentioning today? This contempt case was filed in 2019. After 7 years, you're mentioning that
my
there's
lord,
another
no,
case.
that is a notice
No, we
was
will
put in
see.
that case, Lordship.
You make a separate mention for that.
Lordship, yes. Obliged.
My lord, regarding prompt payment of salary of the petitioner. Accountant General has taken initiative, but service book has not been given by the medical. 30 July 2026, they pass an order in your account of that. Probably on the record it is there.
Yes, this is listed for orders.
Yes, my lord.
Why today?
They have taken step by the accountant general, but health department has sent the pay slip, not with that service record. Service record has not been sent, so
As per the last order, Lordship, we have to submit today whether the service book of the petitioner has been sent to the AG. It is already sent, Lordship. Communication letter 3/8/26. Lordship, may kindly tell us this.
3/8/26.
Yeah, yes, 3/8/26, it is sent to the AG.
You show your plan a copy. Show him.
Give me, Lordship. This is-
Show it to him.
Yes. For issuing payslip law.
Now, who will issue the payslip?
AG,
AG.
AG.
3/8.
Yes,
Today we are only on, what do you call, 6/8,
yes,
correct?
yes,
So some more time is required.
yes.
You tell us. When you'll be able to tell us whether AG, who's appearing for AG? Yes. What is the instruction?
Lordship, we have received instruction on 30 July
Hmm.
of this year. Latest instruction is yet to receive.
Learned Standing Counsel for the Health Department, Miss
Deborah,
Deborah, submits that what has been given?
the certified copy of the service book of the.
Certified copy of the service book of the petitioner has been forwarded to the Accountant General,
Yes,
bracket A&E Assam, on
3/8/26.
3/8/2026. And it is for the Accountant General's office to issue the pay slip.
Yes,
Now, Miss,
Lordship, I'm M. Das appearing on behalf of SK Media.
where is SK Medi?
Lordship, he's on leaves.
Miss M. Das appearing for SK Medi, CGC. I'm sorry, AG Assam. SC AG Assam submits that they are yet to receive instructions in the matter. Of having regard to the submission of the Learned Standing Counsel Health Department, the AG Assam, to inform the court about the status by the next day. List again. We'll have it after 2 weeks. List again on 24th of August.
obliged, Lordship.
Right.
And in this case, my lord, the order, my lord, is violated, lordship, as 15 lordship.
Interference for the respondents also. So I need some time, Lordship. I will.
How many respondents?
For all
all
respondents, but Lordship, only
5 respondents.
5 respondents, Lordship.
You are for all the respondents.
All the respondents, but the fact is that 1 and 2 is no longer holding the post, Lordship. So I am for 3, 4 and 5 now. Because 1 and 2 are already, Lordship, they are
What's your good name, please?
N Upadhyay, Lordship.
N.
N Upadhyay.
N. Mr. N. Upandia, Learned Counsel for the Learned Counsel submits that he will be appearing for respondent numbers 3, 4, and 5. And he praised time for filing show cause reply. He also submits that respondent numbers 1 and 2 are no longer holding their respective office. Mr.
MH
MH
Ahmed.
Ahmed, Learned Counsel, appears for the petitioner. As paid for by Mr. Upadhyay. How much time?
2 weeks, Lordship.
2 weeks time is granted to file the show cause reply.
Lordship.
List again,
May I pray for date, my lord, in this case?
list again on 24th
Obliged.
August.
Obliged.
None appears for the petitioner when the matter is called. Office note dated 3/8/2026 indicate that no affidavit has been received by the section field date.
Lordship,
Mr. P. Bora, Lanati, State Council, appearing for the respondent number
1, 4, 5, 6, and 7.
1, 4, 5, 6, and 7. And Miss
Tinlu.
Tinlu.
Article of that, on the. Number 2.
appearing for respondent number 2. Raised for and are granted further 3 weeks time. File their response. List again after 3 weeks on a date to be.
In this matter, your lordship, Miss Tham Bhattacharjee, she appears for respondent numbers 3 and 4. She just informed that she is on legs in port number 1 in the old building. So she'll take some time, your lordship. The matter may be time, pass over time being, because she is the main party.
Pleadings are complete.
Pleadings are complete.
We'll have another day.
Yes,
Lordship.
Ms. M. Bhattacharjee, learned additional senior government advocate, appearing for the respondents, is said to be on legs in a different form.
Only 3 and 4. She appears for 3 and 4.
Appearing for respondent number 3 and 4.
I appear for 1, 2, and 5.
3 and 4, who are the main respondents, who are said to be the main respondents, is on legs in a different court, and therefore the matter stands adjourned to be listed again. You want a date or something like that?
Yes, Lordship.
When? Any urgency?
Lordship,
Sharma.
he is not receiving the salary of assist to the promoted post, Lordship. So he is
Okay. List again on 20th August 20.
Lordship, obliged.
May it please your lordship, my senior is legs in another court. Kindly pass over the matter for the timing, lordship.
Oh, Mr. Dubey,
Yes, lordship.
what is the matter about?
It's a compulsorily retired petitioner. I'm appealing for the response. That retirement has been challenged by the petitioner.
Okay, pleadings are complete, otherwise?
Pleadings are complete.
So what do we do? Should we wait or we take it, we fix another date?
18 minor.
Lordship, we have urgency, lordship.
What is the urgency? What has to happen has already happened. Compulsory retirement. You are retired already, isn't it? The case of 2023. We are fixing a date. We're not saying that we'll not fix a date. We'll fix a date. Mr. R. Dubey, learned counsel for the petitioner, is said to be on legs in a different court. Therefore, matter stands adjourned to be listed on
18 minor.
18th August. Okay.
Presence may be noted.
Your good
BK
name?
Singh. BK Singh for FCI respond.
Mr. BK Singh, learned standing counsel FCI, appears for the state respondent.
Obliged.
This matter, lordship may dispose of the matter, my lord, already complied, my lord, order. CS.
Please your lordship.
7.
What do you say, madam?
Lordship,
Complied.
Complied, my lord, CS.
What was the direction? Tell me. What was the direction?
Direction. They are, it is not a contempt case, madam, the repetition, they are paying for appointment of the petitioner, madam. Accordingly, she has been appointed, madam.
Petitioners, how many of them?
Madam,
How many of them?
only one.
Where's the order? Is it page 37? It says petitioners.
Earlier, repetition, my lord, filed, my lord, and subsequently,
This is a writ petition, correct?
my lord.
Lordship, in this petition, only one petitioner,
There
Lordship.
was a direction earlier in the earlier round of litigation to appoint a group of persons who fall under the disabilities category to appoint them in grade 3 and grade 4 posts. So, my lord, the petitioner here she came as a single petitioner, asking for appointment as per the direction and passing that petition, my lord.
Petition number 124. 1424.
1424.
1424.
Yes, Lordship.
Yes, so you have been appointed now.
Yes.
Lordship, we have no instruction regarding that. That matter may be taken up at two, Lordship.
Only pay on the second page. Lord. Huh? Packet was-
Let her take the instructions.
Lordship,
You have seen this copy?
Lordship, just now they give.
Okay. We just have a word. We'll take it up at 2.
So my lord, I have some difficulty, my lord.
It's okay. We'll record your presence. Your good name.
I mean, my lord, B Taluk, sending also limited.
This is item number
7.
7. B Talukdar,
My lord,
Standing Counsel.
elementary. Report.
At 2.
Much obliged.
From the offer.
Here we have filed the affidavits.
We have the records.
Yes, my lord, we have received the record.
DPC. DP.
My lord, we have the records also, my lord. So my lord will issue rule and fix the matter for hearing. Oh,
Who's there for the other side?
my lord.
H. Barua, N. Sinha, U. Sharma, P. Bora, P. Pukan, A. Burman. 6 councils are there, but no one is appearing. Obviously, they'll come and say that let it be in the admission. For you, you may want it for a hearing. What to do? None appears for the petitioner.
The dismissal from service, my lord. This has to be heard, my lord, at length.
It can be heard at admission stage also. The preference is always that it should be in the admission stage so that, like hearing, it gets carried away.
But usually, my lord,
If the parties had agreed, I would have passed the order, but since no one is there.
next week, my lord.
Okay. None appears for the petitioner when the matter is called. However, Mr. Aadhar Learned Counsel, appearing for the state, appears and submits that he also has the bundle proceeding records. He also submits that the rule may be issued and matter may be posted for regular hearing. So, however, since the petitioner is not represented, let the matter be listed in the admission column only. When do we have it?
After 2 weeks, my lord.
Mhm. Eighth of September.
May it please the Lord. This matter relates to non-payment of leave encashment and gratuity amount to the petitioner's lordship.
Non-payment of
Leave encashment and gratuity amount. Lord.
leave encashment gratuity.
Lordship, they are the lordship retired employee of Art Fed lordship. Art Fed.
What is that?
Say corporate society.
Cooperative society under government of.
What is the name?
So Assam Apex Weavers and Artisans Cooperative Federation Limited.
Art Fed.
Art Fed in short. Lord.
So what seems to be the problem?
Lordship, they have filed their affidavit, Lordship. They are not denying our entitlement, but they are because of their lack of funds.
Lack of fund.
Yes, Lordship.
Yes, some time.
What are you doing about it? From where you'll get the fund?
We have some stores for selling handloom products.
From the sales, you will
Yes, sales.
generate the fund.
Yes.
How much fund is required?
Here, my lord,
Your lordship, altogether 13 petitioner lordship and some of the petitioner retired in the year 2019 lordship. In 2019, they are waiting for their this amount lordship.
Question is how much fund is required? And how much time will it take to generate the fund?
They have also filed another additional affidavit lordship. It goes to show that lordship it's a profit making organization lordship. Kindly have a look at the last additional affidavit lordship. They have submitted balance sheets since 2022 to 23 lordship.
Page?
Page starts 52 lordship.
$52. Additional affidavit.
Lordship.
Which paragraph?
Paragraph lordship 3, 4 and 5. 2, 3 and 4 sorry lordship.
Profit is 5,37,000.
yes.
Financial year 24-25.
Lordship. Then
Then
23-24 also.
23-24 is 2 lakhs. Then the other one is what? 22-23.
22-23 lordship.
So 2 lakhs something, 2 lakhs. Then now the latest is 24-25 is 5 lakhs.
5 lakhs lordship.
Now 25-26. And how much is due to you in total? 13 petitioners.
I think total we have not calculated lordship, but lordship at this stage, my prayer is that lordship let them verify and pay accordingly lordship to the petitioner lordship. Since 2019 lordship, they are waiting lordship. Some of the petitioners lordship.
I'm sure they want to pay you also, but they don't have fund. There is a problem. You also should claim actually, no? That leave encashment due to me is this much. You're just simply saying leave encashment gratuity. You don't know the figures also. And where do you say that they have not disputed?
Paragraph lordship 7 of their affidavit lordship. Case 49 lordship.
Regarding the petitioner number 10, my lord, we have disputed, my lord.
So this paragraph 7 has no breakup. How much, when? So perhaps that's why you filed the additional affidavit. It is regarding your profit.
Yes.
How much is due to them that has to be not, is not there. The counsel, you have to file one more affidavit showing the up-to-date status. This was filed in August 2025.
Yes.
1 year back. You're saying that in some of them, there was audit going on, non-completion of audit was the reason not for not releasing. And in some case you have released.
Yes.
But how much you have released, when you released, that detail is not there. Please write. Mr.
R. Pukan.
R. Pugan, learned counsel for the petitioners, and Mr.
A. Zahid.
A.
Jahid.
Jahid, learned counsel appearing for the respondent number 2 and 3.
I am for one for
And Mr. Aadhar, learned counsel for respondent number
one.
Respond number 1 and 4. Learned State Council for 1 and 4. So by filing this writ petition, the petitioners who claim to be the employees of respondent numbers 2 and 3 pray for a direction to the respondent authorities concerned to release them the leave encashment and the gratuity as entitled to them. Stop. The learned counsel for the petitioner submits that despite having retired quite some time back, the petitioners are still waiting for the state benefits. Stop. Although the respondent number 2 and 3 have filed their affidavit, an additional affidavit, in response to the writ petition, but the detailed particulars of how much has been released to whom and how much is pending for the persons who are not paid, and what is the status of the audit being carried out. As stated in paragraph 7 of the affidavit dated 26/8/2025. Requires to be clarified. Along with the details. Stop. Therefore, as paid for by the learned counsel for respondent number 2 and 3. How much time? 2 weeks?
2 weeks.
2 weeks time is granted to file the required particulars in the form of an additional affidavit. List again. On 7th of September.
Okay.
Ma'am, please, Your Lordship. Lordship, the matter relates to family pension and arrear family pension, Lordship, non-payment of family pension and arrear family pension. In this matter, Lordship, the petitioner's father was working under Indian Army under Army Medical Corps, Lordship, and he retired in the year 1979. After that, he expired in the year 2007, Lordship. The petitioner's mother predeceased her father in the year 1981, Lordship. Now, the current situation here is that, Lordship, petitioner's father has wrongly written her mother's name as Sucharita Das instead of Malti Das. In every document of petitioner's mother, her name has been recorded as Malti Das, Lordship. But only in the service record, service book of petitioner's father, her name has been recorded as Sucharita Das, due to which the department is not releasing the family pension, and accordingly they have asked her to submit all her documents. And the petitioner has shown one affidavit also, stating this both the person are same, Sucharita Das and Malti Das, both the person are same, Lordship. And lastly, they have the respondents have given one representation, which was in the month of November of 2024, where they have stated that you have to verify the name of your mother, Lordship. Now, Lordship, even after producing all the documents, they are not willing to accept the case of the petitioner, Lordship, and release the family pension, Lordship.
Your father retired when?
1979, Lordship.
Until now, no pension.
No, Lordship. After the death of petitioner's father, she is not getting any pension. In the same department, Lordship, her brother is also working and he has also given the same declaration that both of their parents' name are same. And petitioner has also submitted relationship certificate, which also they are not accepting.
Here you have written with effect from 1/11/2007.
After petitioner's father expired, Lordship. His father expired in the year 2007, Lordship.
Father was in the Army Medical Corps,
Yes, Lordship.
MC.
Yes.
And after retirement,
After after the death of petitioner's father, she is not getting.
petitioner is the daughter.
Yes, Lordship. She is a 55-year-old lady who is deaf and dumb, Lordship. Her disability certificate is in annexure number 7, page 30, Lordship.
Mother expired 81, father expired 2007.
7.
Died in harness or after retirement?
After retirement.
Then he was getting some pension.
Yes, Lordship.
He was enjoying pension.
Yes.
After his death, the daughter will get.
The daughter will get, but she is not getting, Lordship.
Daughter is what? Unmarried?
Unmarried. Deaf and dumb, unmarried. She is not working anywhere.
And what about the discrepancy in the name? It's in the certificate of the daughter?
In the service book, Lordship.
Service book of the father?
Of the father, Lordship.
How come father does not know the name of the mother?
Actually, her maiden name is Sucharita Das, but in all her official documents, her petitioner's mother name has been recorded as Malti Das, Lordship. So that is the confusion they are creating. So for that, the petitioner has sworn one affidavit also, which is annexure.
So matters relating to AMC comes before this court? Medical courts. Yes, what is your response?
Annexure 15.
Lordship, there is no material instruction regarding the completion of verification of the name of the person. Lordship.
Have you filed affidavit?
We have filed affidavit.
They have filed affidavit also. We have also filed our reply, Lordship.
Okay.
We have not received, Lordship, as per official the rejoinder affidavit is not received, Lordship.
You have not supplied rejoinder?
We have filed.
No, you have filed, but have you supplied copy?
No,
Without supplying, we cannot file, Lordship.
Why not? Sometimes you file by undertaking also.
kindly peruse the office note, Lordship. 4/8.
4/8. No rejoinder affidavit has been filed, received.
Affidavit in reply, we have filed, Lordship, against the affidavit in opposition.
As per earlier.
I go by the office note. You see, you may say so many things, but office note says no rejoinder affidavit. So how do we generate your rejoinder affidavit like that?
Not received.
You have a filing number and all that, whatnot. You have that. Take it up before the registry. Although the learned counsel for the petitioner submits that she has filed the rejoinder affidavit, the office note dated 4/8/2026 indicates that no rejoinder affidavit has been received by the section. Under the circumstance, cancel that. Learned counsel for the learned CGC,
Lordship.
Miss
M. Bora, Lordship.
M. Bora.
SP Chaudhary. On behalf of SP Chaudhary.
Miss M. Bora, learned counsel appearing on behalf of Mr. SK Chaudhary. SP Chaudhary, CGC, representing the respondent, also submits that she has not received a copy of the rejoinder affidavit. Under the circumstance, the petitioner to take up the matter with the registry. If the affidavit rejoinder has not been filed, the same be filed within 10 days. List again. List again. On 9th of September.
Before that, Lordship, can it be possible? Last week of August?
No, 2nd of September. Okay.
Obliged, Lordship.
My lord, I am extremely sorry for interruption, my lord. So item number 2, that was at my instance, that was listed. So because of difficulty of the CGSC, he is sick, take my lord time. So I also given consent. But the case is fixed on 3rd of September. So my lord, this 3rd September is little difficult on my part. It may be on 2nd of or my lord 6th, my lord.
Second is all day. No, not all day.
6th, my lord.
6 is Sunday.
Then my lord, next 7, 8, my lord.
8. Item number 2.
2, my lord. The
Just change
steno
the
was
date,
my lord,
okay?
the difference steno.
Item number 2, you make it 8. Okay, whoever's taken it, just all right.
My lord.
Yes.
Lordship, I retired from the service of the respondent bank on 30/6/2018. And then on 28/2018, my gratuity has been sanctioned for an amount of 15,88,062. But I was paid less by an amount of rupees 3,07,460. So I have made several representations. I have personally followed up also, but no positive response have been found. To cut the whole story short, I would like to request you to kindly go through page number 24, Annexure 8, where the whole story has been narrated.
Page number?
Page number 24, Annexure 8. May I read it?
How much is your gratuity amount?
Total sanction amount is 15,88,062 that has been sanctioned. But I was paid less by an amount of rupees 3,07,460.
What happened? You had some due.
Yes, that I am coming, Lordship. Page number 24, Annexure 8. I have covered earlier representation also. It has been, the whole story has been summed up here.
Just a minute. Huh? $15,88,062, is it?
Lordship,
Total amount was 15,88 and
15,88,062.
okay.
And I have been paid 12,80,602.
You are working as what? You are working as
An officer in the scale 2 category manager.
officer scale 2.
Yes.
In the bank.
Lordship,
Which bank?
in Assam Gramin Bank.
Grameen Bank.
Yes, Lordship.
Okay. Now page 24.
Page 24.
This is dated 25th, 7th of
7/2/2025. Here I have narrated the whole, that the petitioner has narrated the whole story. Prayer for release of undisbursed part of gratuity amount of rupees 3,07,460. I have the honor to lay the following few lines before you and hope for gracious consideration at your benign hands. This is addressed to the chairman of the respondent bank. That, sir, I had joined erstwhile Praxis Gauhati Bank and constituent of Assam Gramin Bank on 4/6/1984 as field supervisor and retired from the service of the bank on 30/6/2018 as manager from Gauhati branch after attaining the age of superannuation. Next point is that, sir, as per bank's calculation, I was entitled for gratuity for an amount of rupees 15,88,062, and the same was sanctioned on 28/2018 by Assam Gramin Vikas Bank gratuity fund. That, sir, out of the said amount, only an amount of rupees 12,80,602 has been disbursed in 3 different accounts, and the remaining amount of rupees 3,07,460 was not disbursed to me. Then, sir, on 21/8/2018, that, sir, as an amount of rupees 3,04,60 only was disbursed less than my actual entitlement, I represented before you filed letter dated 21/8/2018 to release the same at the earliest. So my representation dated 21/8/2018 is in page number. Then, sir, I had visited both Kokrajhar regional office and head office of the bank a number of times during the year 2019, 21, 22, 23. In one of my visits, I was told that Kokrajhar regional office that said amount was lying at the deposit suspense account. That means the amount has been kept in sundry deposit. That has not been adjusted anywhere. That, sir, on 17/4/2024, I had submitted another representation that has not been disposed of. That representation is in page number 18, Annexure 3. Then, sir, finding no other alternative, I have submitted two RTI applications. One is on page number 19, Annexure 4, and the other is in Annexure, the second Annexure. Then I have to come to know that the said amount of rupees 3,04,460 was deducted from my gratuity amount on account of demand raised by Income Tax Department in the name of Assam Gramin Vikas Bank, Tamarhat branch. That, sir, the demand raised by the Income Tax Department pertains to the bank, and it is no way related to me. Moreover, I was never informed about the liability of such type of before deducting it from my gratuity. Sir, if you kindly look at page number 23. Page number 23. The demand raised was to Assam Gramin Vikas Bank Tamarhat branch. It is not raised upon Anwar Hussain Talukdar. I am the petitioner. I am Anwar Hussain Talukdar. The demand raised by the department was upon the respondent bank, not upon the petitioner. That, sir, from the reply of Central Public Officer of the bank dated 9/1/25 in response to my RTI application, the authority has admitted that no communication was given to me before adjustment of the amount. Thus, it is very much clear that the said deduction was without any authorization on my part. Sir, that is in page number 22. Page number 22, Lordship, kindly come to page number 22, point 3, point number 3. Page number 22, Annexure 7, point number 3. Whether prior information was given to the undersigned in respect of adjustment of such liability. Communication is not available with us. That means no prior intimation was given. I was not put to notice before the adjustment of rupees 3,07,460 from my gratuity amount. Lordship, I would like to point out any recovery from emoluments or any amount due to an employee is covered under the penal provision of the staff service regulation. I would like to bring to your notice the provision as contained in the regulation 39(4). Lordship, 39(1)(4).
Hmm.
39(1)(4). Recovery from emoluments or such other amounts as may be due to him of the whole or part or any pecuniary loss caused to the bank by negligence or breach of orders. So recovery can be made only under this regulation, adhering to the prescribed rules of this regulation. He must be put to notice. He must be heard. That is there clearly embedded in this regulation, that he must be put to notice, he must be heard. Only then the recovery can be effected. And neither during his service period nor after his retirement, he has been put to notice of any liability. Now I would like to, he is a pensioner, Lordship. I would like to draw your attention to the regulation, pension regulation. It is in page 60, regulation 44. When after retirement, gratuity can be adjusted.
What are you saying? Pension?
Pension regulation.
Pension manual.
No. This is bank's pension regulation.
Where is the regulation? It's here only. No.
I have, Lordship, page number 60, regulation number 44. Provisional pension. An employee who has retired on attaining the age of superannuation or otherwise, and against whom any departmental proceedings or judicial proceedings are instituted, or where departmental proceedings are continued. We can come to the straight 2. In cases referred to in sub-regulation 1, the gratuity shall be paid to the employee and only on conclusion of the proceedings, and any recoveries to be made from an employee shall be adjusted against the amount of gratuity payable. But here in this case, I retire from the service on 30/6/2018. I have been paid a part of my gratuity amount on 28/2018. There was no disciplinary proceeding continuing at that point of time. So there is no point that my gratuity can be deducted or adjusted on account of any liability. That is my point, Lordship. I would like to draw an identical case against the same respondent, which is almost same given by this honorable court only. The order in case number WBC 9499/2019 is an identical case. The amount of leave encashment has been deducted from the venture capital liability. I would like to invite your attention to para 11 and 12. May I read it, Lordship?
Yes.
The spirit of Article 14 of the Constitution of India is ingrained in any such decision taken by any authority which will have a civil consequence on any individual. It is not necessary to specifically provide it for compliance of laws of natural justice. It is ingrained in every procedure when any such authority, including bank authorities, contemplate to initiate any action against any employee which will have a civil consequence. It is implicit that before the authorities to come to a finding regarding the alleged misconduct of the guilt of any officer, the petitioner ought to have been put to a notice. In the instant case, I have not been put to notice. Without complying such procedure, any action that may be taken by any such authorities, including the bank authorities, arriving at a conclusion in respect of such misconduct and thereby passing consequential orders like withholding of financial dues, that too when the officer has already retired, I am already retired, already superannuated, is completely unacceptable. Can I come to the point number, para number 12, Lordship?
Yes.
In view of the above discussions, it has to be held that there is no material place before this court that bank has arrived at a finding that towards the guilt of the petitioner calling for consequential action involving civil consequences. Here he is facing civil consequence. There can be no decision to impose penalty or pass consequential adverse orders against any officer without the person being put to notice. I have not been put to notice. And a procedure acceptable in law followed by the authority to arrive at a finding that the person concerned is indeed guilty of the allegation made against him. So, procedure as per staff service regulation of the bank while he was in service, even after retirement under pension regulation has not been followed. So, the deduction of 3,07,460 is completely illegal and arbitrary. And so, I pray before your Lordship to direct the authority to release the balance amount of gratuity to the tune of rupees 3,07,460 together with up-to-date interest within a definite period. This is my humble submission.
Lordship, the Lordship comes to page 17 of the writ petition.
Now there are two representations which he claims that he had sent. Now we have in our affidavit denied the receipt of these representations, but we have denied that we have received these representations. But Lordship will have a look at page 17. Because his case is that he was never put to notice. Not this is a letter dated 21st August 2018. Is a prayer for release of the remaining part of gratuity amounting to rupees 3,07,460. Now he says, most humbly and respectfully, I have the honor to inform you that I have retired from our AGV Bank, Abhayapuri branch on 30/06/2018. Our regional office Kokrajhar has deducted rupees 307,460 from my retirement benefit of gratuity on 20/08/2018 as because the additional ACIT TDS Gauhati Aikar Bhavan GS Road Gauhati served one reminder letter on 20/09/2017 due to delay in submission of TDS statement from our remote area Tamarhat branch. At that point of time, petitioner was branch head of the Tamarhat branch. That is why, my lords, this income tax notice is related to that period when he was the branch head of that branch. As per advice of our regional manager Kokrajhar and at the time of submission TDS statement to our Bharatiya and Company Fancy Bazaar Gauhati, I have provided 2 times of penal charge from our Tamarhat branch more than rupees 14,000 during the month of April and May 2015, and accordingly I submitted duly all the pending statements. So, my lord, he does not deny that he was the branch head. He does not deny that he is aware of the deduction of the withholding of the gratuity amount. Also does not deny that the income tax department has sent a notice. So, my lord, this is his own representation, which is part of the writ petition, page 17. So, this as far as the first, the notice part is concerned. If your lordship comes to, my lord, the next page. So, after 2018, my lords, this is the representation in 2024. This also we have denied that we have accepted, but be that as it may, my lord, in this he has said that now I have come to know that the bank has deducted 3,07,000 so and so. So in 17 he says that yes, I know that 3,07,000 has been deducted from my gratuity. That is what he says in page 17. Though we have denied receipt, but this is his own document. So after 18 Malas 2024, now thereafter, my learned senior colleague has already read out the entire thing. Now, if your lordship comes, my lords, to page 22, this is in reply to the RTI. Now, when he is already aware of that the deduction, the reasons for the deduction of gratuity, why he had to go to for RTI, that's a different reason, but lordship will kindly have page 22. Now, in the reply, my lords, of this serial column number 1, name of the account holder in whose account the amount of 3,07,460 has been credited. The amount was temporarily realized on bank account on 20/08/2018, and then it was remitted to the income tax department. Nature of liability, liability pertaining to income tax department. Whether prior information was given to the undersigned so and so. They say communication is not available with us. However, intimation of outstanding demand of income tax from income tax department to Tamarhat branch was shared while you were in the capacity of branch manager of Tamarhat branch. Copy enclosed. So now page 23 is the copy that was enclosed with the RTI reply notes, which perhaps my learned friend has read out. So this is the penalty imposed on the bank. Of course, it is in the name of the bank because the income tax demand is in the name of the bank only. Now comes the role of the petitioner. And he has the affidavit in opposition that we have filed. Page starts at page 27, lordship will kindly have page 33. Now, this is a circular dated 6th of August 2010. What was happening was that since a long period of time, the respective branches were not submitting the income tax statements in time, for which bank was repeatedly facing the penalty orders and these sort of things. And that's why the competent authority of the bank issued this circular, and the tax at source, deposit of tax to the government account, obtention of declaration form so and so, submission of quarterly ETDS return. Bank has issued specific circulars containing the detailed guidelines relating to tax deducted at source and methodology to be adopted to deposit the same in the government account.
Despite existence of such guidelines, serious irregularities are committed by some of the office's branches. Such lapses will not only invite complicacy for the bank, but also attract imposition of penalty by the tax authorities. Some of the common irregularities as has been observed as against the actual norms are enumerated hereunder for information and guidance of all concerned. So we have, there's a complete list of what is being done and what should be done. And if your lordship comes now to page 35, which is the operative part, this part, further to bank circular. Lordship, have it, page 35. Second list. Further to bank circular number so and so dated 19 June 2008, it is reiterated that regional offices are required to monitor and supervise the branches and submit a certificate on quarterly basis within 1 month from the date of completion of the quarter, to the effect that all branches, offices under their jurisdiction have complied with the aforesaid instructions, including filing of the ETDS returns with the appropriate authority within the prescribed time schedule. In case any penalty is imposed by the competent authority due to wrong, irregular, non-filing of ETDS returns, the concerned head of the office will be personally responsible for payment of such penalty. All concerned are advised to follow the instructions scrupulously. This is the circular of 2010, in which it was made clear that if any of the branch heads defaults, he will have to suffer the penalty for that. Now, your lordship will kindly have page 38. 38 is the demand, in fact, that was raised upon the bank by the income tax department. And the subject itself makes it clear, the outstanding demand of late filing levy against your TAN matter regarding the demand of the late filing levy of rupees 303,583 against your TAN so and so is outstanding for a long time. As per section 221 of the IT Act, where a person is in default or is deemed to be default in making payment of tax, he shall, in addition to the amount of the arrears, be liable to pay such amount by way of penalty. And in the cases of continuing default, such further amounts as the assessing officer may direct from time to time. Now, next 2 paragraphs are on the law. And in the last, in case of your failure to pay the demand or rectify the statements by 30/09/2017, this office will be constrained to take action as per Income Tax Act. Thereafter, my lord, bank realized that there is a pending demand against that branch. And in fact, my lord, the petitioner was then the branch head. So it was, as per the circular of 2010, it was his responsibility, my lords, to file the income tax returns in time. And in 2018, as per his own letter, he is aware of that. At page 39, my lords, is the concerned details of the demand raised. Now, your lordship will kindly have, my lords, the page 41. Page 41 concerns, my lord, the release of the retirement benefits, because he had retired on 30th of June 2018. My lords, this is, my lords, release of gratuity amount. This is to inform you that gratuity claim, sorry, claim amount of the following X staff has been settled and we have credited the amount in your interest all account. Please arrange for release of the amount to the respective officer employee as mentioned below. After realization of all kinds of liabilities to the bank, please ensure the logical closure of all loans advances, including any other liabilities before release of the fund. Please note that TDS on gratuity amount so and so, the liabilities as informed by you by your letter number so and so dated 3/8/2018 should be taken care before payment. And this communication, my lords, we have said that it was sent to the petitioner, my lords. The lordship has the, my lord, we do not have the postal receipt because it's 7 years ago this thing happened. But we have the extract of the dark register, my lord, 42. We maintain this sort of registers. And this information, this communication was sent on 14th of August 2018. And at the very top, my lord, serial number 2498, this was sent to him at his post-retirement, his permanent address. Well, all of these documents, starting from page 17 of the writ petition and the other representation and these letters, look, it cannot be said that he was neither put to notice nor he was not aware, because in page 17 itself he says that yes, I know that this has happened.
This come to page 17 again.
Yes.
How do you say that you knew about this? This was addressed to the chairman.
Yes, addressed to the chairman.
By the petitioner.
Yes. Though we have said that we do not receive it, but since it is his own document, if we go by this own document also, he's saying that, yes, I know. what happened in 2018. I know that the income tax department, because of this reason, the amount is withheld. If your lordship, for a minute again goes to my lord paragraph 2. Our regional office Kokrajhar has deducted rupees 307460 from my retirement benefit of gratuity on 20/08/2018, as because the additional ACIT TDS Gauhati Aikar Bhavan, this is the tax authority, served one reminder letter on 20/09/2017 due to delay in submission of TDS statement from our remote area Tamarhat branch. And thereafter he says that after the advice of the regional manager so and so, he has done some actions in the year 2015 and he has later submitted the pending statements. But the bank had to pay the penalty amount of 3,07,460. And this relates to the period when he was the branch head, the branch incumbent of the concerned Tamarhat branch. So he was well aware of what his duty was as a branch head, including the submission of the TDS returns. And this is a statutory default.
Who is the responsible for that submission of TDS statement?
The branch head, as per the circular of 2010. Because it is clearly mentioned in the circular that
It is not the individual lordship, it is the
my
branch.
learned friend will have his chance while he is so eager.
As per circular of 2010.
Yes, page 33, 6th August 2010. All the details of what is being done, the wrongs that are being done by the various branches, not only this branch, but so many other branches. And at the end, it is made quite clear. But ultimately, this is also 3,07,000. If he is ready to refund to the bank, then we will release the gratuity. No difficulty. But that money has to be, this is also public money. It is very made extremely clear in the circular that the concerned head of the office will be personally responsible for payment of such penalty.
This penalty is regarding delay.
Delayed submission of the TDS statement for the branch. And as to the period that is there, that also we have annexed, that is at page 39. During this period, he was the branch head. Earlier period, it's okay, it's no problem with the TDS returns and all that. But during this period, this person was the branch.
The third paragraph again says, as per the advice of regional manager, the time of submission of TDS, I have provided 2 times of penal charges from our Tamarhat branch, more than rupees 14,000.
He says, I have provided to whether it is from his individual account or the branch, that is not clear from this letter. Because this is simply not in our record. He can clarify if he has paid from his own pocket, that's a different thing. Or if he has paid from the branch account, that is. But the fact remains that the statutory demand was levied on us. And this was very much a part of his duty. And he was well aware as per his own document in 2018. So this put to notice argument, my lord, cannot work in this. He's well aware as to how the deduction has been done and why it has been done. And between 2018 and 2025, my lord, there is nothing on record to suggest that he made any representation.
No, one thing is there, like supposing even if he is well aware,
Gotcha.
will that be sufficient
Look,
to
ordinarily,
waive the usual statutory notice or something like that?
Statutory notice, my lord, one has to say that if a specific notice to show cause, whether it was issued within the retirement, before his retirement, no, it was not done. But in 2017, my lord, for the first time, because the demand from the income tax department came in 2017. And 2017, for the first time, this demand came. And in June 2018, he retired. So the gap therein was.
He retired in June 2018?
Yes, 30th of June 2018. And the demand, my lords, that we have shown, that is, my lord, that 20th of September 2017 is the date. We have received it after a few days, my lord.
Okay, look, I'll come back 5 minutes.
Normally go to the controller of gratuity under section 7. There is of the Payment of Gratuity Act. The Payment of Gratuity Act, 1972.
Payment of gratuity act. Parent will be there. Parent. P. Payment of gratuity act. Section 7.
Section 7. Determination of the amount of gratuity. Wherein, my lord, section, subsection 1, 2, my lord, 3, 3A, and more specifically, my lord, there is 4A. But this part, 4A, if there is any dispute as to the amount of gratuity payable to an employee under this act, or as to the admissibility of any claim of or in relation to an employee for payment of gratuity, or as to the person entitled to receive the gratuity, the employer shall deposit with the controlling authority such amount as he admits to be payable by him as gratuity. Where there is a dispute with regard to any matter or matters specified in clause A, the employer or employee or any other person raising the dispute may make an application to the controlling authority for deciding the dispute. The controlling authority shall, after due inquiry and after giving the parties to the dispute a reasonable opportunity of being heard, determine the matter or matters in dispute, and if, as a result of such inquiry, any amount is found to be payable to the employee, the controlling authority shall direct the employer to pay such amount, or as the case may be, such amount as reduced by the amount already deposited by the employer. The controlling authority shall pay the amount deposited, including the excess amount already deposited by the employer, and so forth. So all these detailed procedure is there in section.
It is there, not disputed. But here is a case, it's not regarding dispute.
Yes.
This much is not fixed, this work should have been this much. It's that some deduction has been done. Case of the petitioner that it was deducted behind his back.
Yes. And
your endeavor is saying that he knows about it.
He knows about it.
So
and
that is the story.
Prima facie, page 17 by his own document. And between 18 to 25 minutes, he did not challenge that part at all. This deduction, this withholding or deduction of the gratuity amount. Because this is not a case where this is he is alleged to have misappropriated some amount. No, that he has not done. He has done what is a default. And the circular says that personal liability will be there of the branch.
But even if it's default, then that is the crux.
That is the crux. That,
you have made your
that
explanation.
I understand, that is there. But the fact of the matter is that putting to notice in this part, perhaps, even if a show cause notice specifically was not sent, but the fact that he is aware of that, page 17 and the subsequent developments thereafter. So he was very much aware in 2018 that yes, my gratuity has been withheld or adjusted for this reason. This is the reason. So 18 to 25, he doesn't challenge it.
So how far this annexure A, page 33 would be relevant?
Lordship.
This is issued by whom? The bank itself.
By the bank itself in 2010. So that all the branches, all the regional offices, they are aware as to what their duties are, so that they submit the returns in time and avoid this kind of situation. That is
basically a warning. You see, if you don't do this, you will have to suffer like that sort of thing.
In an ideal situation, yes, he should have been put to notice. There should have been a show cause. There should have been all that should have been done. But here is the case. Ultimately, this bank's money is also public money. This 3,07,000 statutory demand, this penalty was levied because of his conduct. Now, if we read page 17, he does not specifically say that no, I have not committed anything or I should not have been done. That is his own document, which though we are denied receiving, but page 17 to that extent. He says that yes, I have done certain steps. But if your lordship's his query is whether a full-fledged proceeding, no, that was not. And perhaps it was that time gap between 2017 September and his retirement. Had they even issued a show cause notice in that period, perhaps Well, there's a judgment of the Supreme Court in Mahanadi Coalfields case, which says that if you initiate, you can carry on, impose punishment retrospectively, and misconduct on that aspect that is there. But here, perhaps misconduct not of the kind that we normally see, but in the fulfillment of a statutory duty. That was not done because he ultimately was also in a fiduciary position, let us say, in a responsible position. But perhaps the full-fledged proceeding was, in the facts of the case, perhaps desirable. One aspect of the matter, if your lordships are inclined to direct that gratuity thing, lordship will leave an option open to the bank to recover in any manner known to law. That option, lordship, bank may pursue a money suit, for example. That may not be foreclosed because if the bank wants to pursue, that option is kept open. That will not prejudice him. He will have his defenses in whatever court of law is there. Because the fact remains that he has also come to the court after 7 years. So if I tomorrow start, I cannot recover from his retirement benefits, yes. But I can approach a civil court or whatever forum. That option, in accordance with law, lordship will keep that open.
Okay. Any reply?
Lordship, already the payment of gratuity act has been verified from your side itself. So that is not applicable in our case. So he is basically relying upon my representation on 21/8/2018. Lordship, come to page number 30, kindly. First para, third line. It is stated that no record of any such representation dated 21/8/2018 and 17/4/2014 could be found in the bank records. Now he is relying on this on 21/8/2018. I have submitted this representation, and in subsequent representation also, I have been quoting this representation. Lordship, if you kindly see my final representation dated 7/2025, before I come to this honorable court, at point number 4.
When was this amount released to you?
Sir?
When was this amount released to you? This 12 lakhs?
20/08/2018.
18. So this writ petition is of 2015.
Yes, Lordship.
Right. So what did you do in the interim now? 19, 20, 21, 22,
Lordship,
20.
I have explained these details in para 15 and 16. In fact, the respondent bank has failed to work as a model employer. I have, after giving the representative also, as an ex-employee, ex-officer of the bank, I have been following up personally at the regional office and head office of the bank, and that has been specifically stated in my writ petition. That it is stated that there is no intentional delay and laches on the part of the petitioner in preferring the present application. In as much as on various occasions, the respondent bank had assured the petitioner for favorable consideration of his grievances, but till date the respondent authorities are sitting over the representation and nothing has been done as regards the legitimate claim of the petitioner. Under such circumstances, the petitioner has approached this honorable court for redressal of these grievances. Lordship, in fact, in point number, para number.
All right, Mr. Counsel, I think we'll dispose it of just now. Okay. We have heard you. Heard Mr.
R.K. Sharma.
R.K. Sharma. This is item number, which item?
11.
11. Heard Mr. R.K. Sharma, learned counsel for the petitioner, Mr. A. Ganguly, learned standing counsel, Assam Gramin Vikas Bank.
Assam Gramin Bank now. Vikas is no more there, but its name is changed.
Assam Gramin Bank, respondents. Anybody else? That's all. By filing this writ petition, the petitioner prays for a direction to the respondent authorities to release him the balance gratuity amount of rupees
3,07,460.
3,07,460, which has not been released to him. Stop. It is the case of the petitioner that he was working as branch manager,
Manager.
was working as a manager under the State Bank, and he retired on superannuation on 30/6/2018. Stop. Apart from other retirement benefits, the amount of gratuity that was entitled to him was calculated at the tune of rupees 15,88,062 by the respondent bank themselves. Stop. However, out of the said amount, only an aggregate amount of rupees 12,80,602 has been disbursed to him, and thereby leaving a balance of rupees 3,07,460 as the unpaid amount. The petitioner, being aggrieved with the same, filed his representation before the chairman of the bank on 21/8/2018. Bracket annexure 2. Requesting the release of the balance amount. So, although some assurance was given to him, but since the amount was not released, the petitioner again submitted his representation before the state authority on 17/4/2024. And thereafter on 7/2/2025. Stop. As his grievance has not been addressed, the petition is before this court through the instant writ petition. Stop. Mr. R.K. Sharma, Learned Counsel, submits that the petitioner submitted an RTI application seeking certain information about as to why the amount has been withheld. Stop. In response, the petitioner was informed by the RTI bank and by the Central Public Information Officer and Head of Department of the bank on 9/1/2025 that the amount was temporarily realized on bank account on 28/2018, and then it was remitted to the Income Tax Department. Stop. The nature of liability was an liability pertaining to the Income Tax Department. Stop. To the query of the petitioner as to whether prior information / intimation was given to the petitioner or not, it was stated that such a communication was not available, but the intimation of the outstanding demand by the Income Tax Department was shared with him in his capacity as branch manager of Tamarhat branch. Stop. The Learned Counsel submits that, in fact, the outstanding amount is the liability of the bank, and the same cannot be the outstanding it cannot be the personal outstanding of the petitioner himself. Which can be seen from the intimation of the outstanding demand given by the income tax department. Stop. Therefore, making the petitioner liable to such an outstanding amount is arbitrary and illegal, and therefore a direction be issued to the respondent bank to release the amount with interest. Next para, the learned counsel submits that the petitioner was not put to notice at any point of time, as can be seen from the RTI reply. And therefore, in absence of any such notice or a proceeding, the deduction of the gratuity amount amounts to deprivation of the petitioner of his right to enjoy the gratuity amount. Stop. It is not even a case that a proceeding was drawn against the petitioner, and the same has been recovered in the form of a penalty. The learned counsel submits that a case of similar nature had come up before a coordinated bench of this court. In the case of Abani Kumar Das versus Assam Grameen Vikas Bank and two others. Bracket WPC number 9499 of 2019. Close bracket. And this court by order dated 2/4/2024. Upon coming to the conclusion that the petitioner therein was not put to notice of any kind prior to. This was regarding what? This was leave encashment, isn't it?
Leave encashment is
Prior to deduction of the leave encashment, held that the said deduction was not tenable in law, and accordingly allowed the writ petition by directing the respondent bank to release all the retirement dues including the leave encashment areas without further delay. Stop. The learned counsel submits that the said decision is also squarely applicable to the present case, since the petitioner was clearly not put to notice. Next para, per contra, not the same para. He therefore submits that the balance amount of the gratuity amount should be directed to be released to the petitioner along with appropriate interest. Next para, per contra, Mr. A. Ganguly, learned standing counsel of the bank, submits that the petitioner may not have been issued notice, but he was very much aware about the fact that there was an outstanding amount which remained unpaid. Stop. In this connection, the learned counsel has drawn attention of this court to the representation of the petitioner dated 21/8/2018, wherein the petitioner had stated that the deduction made was on account of delay in submission of TDS statement from the Tamarhat branch. Stop. In this connection, the learned standing counsel further submits that the bank has daily circulated appropriate instructions to all branches providing that in case of any penalty being imposed by the competent authority due to wrong, irregular, non-filing of ETDS returns, the concerned head of the office will be personally responsible for payment of such penalty. Such circular has been issued way back on 6th of August 2010. And the petitioner, being the branch manager of Tamarihat branch, ought to have known that ought to have known about the said circular. Stop. Therefore, the deduction made is only justified. Mr. A. Ganguly further submits that even the writ petition is belated in view of the fact that the petitioner had retired from service on 30/6/2018, and he had been released the gratuity amount, although not in full, soon after his retirement. But for reasons best known to him, he has approached this court only in the year 2025. He therefore submits that even on account of delay, the writ petition would not be maintainable. Next para, Mr. A. Ganguly also submits that in a matter regarding dispute pertaining to gratuity, there is a provision under the Payment of Gratuity Act 1972, more particularly Section 7, bracket 4, bracket small a and b. Stop. The same provides for determination of the amount of gratuity. And in case of any dispute, the employer is required to deposit the admitted amount before the controlling authority. and the employer or employee raising the dispute has to make an application to the controlling authority for deciding the dispute. Stop. Clearly, the petitioner has not availed of such remedy, and therefore the writ petition also would not be maintainable on this ground. Next para, I've heard the submissions made by the learned counsels for the private party, and I have produced the materials available on record. The issue to be decided as to whether the deduction of the gratuity amount would be permissible on the grounds mentioned, on the grounds taken by the respondent bank. Stop. There is no dispute to the fact that the amount of gratuity has been assessed and calculated at rupees 15,88,062. Stop. The only issue raised by the petitioner is that the entire amount has not been paid in full, and there remains a balance of rupees 307,460. Stop. Having regard to the same, it only appears that the provisions of the Payment of Gratuity Act as submitted by the learned standing counsel of the bank would not be attracted, because the amount to be payable to the petitioner is not in dispute, but the deduction. But it is the deduction which has been challenged. The petitioner had submitted an RTI application seeking for certain information from the bank, and against the query as regards the petitioner being issued notice or given any intimation about the deduction, has been answered by stating that there are no documents available to provide. Stop. It is also the case of the petitioner that he was not put to notice prior to such deduction. Stop. Although Mr. Ganguly, learned standing counsel for the bank, has tried to impress upon the court that the petitioner himself was fully aware about the fact that on account of delay in submission of TDS statement, an amount of rupees 307,460 had been deducted. From his retirement benefit of gratuity on 28/2018. Stop. Therefore, as he was of the knowledge about the said deduction, and in view of the circular issued by the competent authority of the bank on 6/8/2010, which the petitioner is supposed to be well aware of, the deduction made is only justified. The said submission, although appealing, perhaps, but in the considered view of this court, is not found to be justified on the ground that the knowledge of a person about a certain fact by itself cannot take the place of a notice being issued to that person. Stop. The purpose of issuing a notice is to put the person on guard and also requiring him to justify as to why any punitive action should not be taken against him for a certain default. Stop. In such circumstance, the person who is put to notice would have the opportunity to make a response and defend himself by whatever means and provision which is available. Stop. The bank, Assam Grameen Bank, also has a service regulation known as the Assam Grameen Vikas Bank of bracket Officers and Employees Service Regulations 2010. Wherein, apart from issuance of notice or following of the principles of natural justice, one of the minor penalties provided therein under Regulation 39, bracket 1, bracket small a, bracket small Roman 4, is recovery from emoluments or such other amounts as may be due, in whole or in part, for any pecuniary loss caused to the bank by negligence or breach of orders. Stop further. The regulations of the bank of the year 2018 under Regulation 44, bracket 2, provides that the gratuity of the employee shall be paid only on conclusion of proceeding or any recoveries to be made from the employee. By adjusting the same from the amount of gratuity payable. To stop, however, in the instant case, no such process is discernible. To stop, in fact, it is not in dispute by, it is not a fact in dispute that no such proceeding has been drawn against the petitioner. And that a notice to this effect has also not been issued. Under the circumstance, this court is of the considered view that the amount deducted from the gratuity of the petitioner would not be sustainable. And accordingly, the respondent bank is directed to pay the petitioner the balance amount which has not been released to him.
Lordship, a timeline may be kindly given and interest portion.
You have come late, why should we give you interest?
I leave it to you, Lordship, but already late.
Within a period of 4 weeks from the date of receipt of the of this order, failing which the amount shall carry an interest at the rate of 6% per annum till the same is till the entire amount is paid.
Only one thing, regulation 2018, before that pension regulation 2018.
Oh, I see. Regulation 2018, I said, no? You make the full form. This is called Assam Gramin Vikas Bank, bracket, employees, close bracket, pension regulations, comma, 2018. Given the full form.
That 6% per annum will be from the date of the order today? No, the lordship is not indicated, otherwise.
Yes, 6% from the date of this order.
No, that liberty may be given to the bank to proceed.
Why should we give you liberty?
No, otherwise, my lord, if they want to proceed, my lord, they can, whatever, my lord, not in departmental proceeding, of course, but as per law, lordship, you can indicate, my lord, because there is a possibility of that perhaps. I'm not sure.
That can be done either way also.
This option will be foreclosed because the limitation period might come into play. So what lordship will only indicate, my lord, that if they want to invoke, they can in accordance with law. Then let the court decide whatever is correct.
Okay, notwithstanding, okay. It is, however, provided herein that if the bank decides to proceed against the petitioner for
Lordship,
default on his part, the same can only be done in accordance with
law.
in accordance with law
In accordance.
and not otherwise.
Lordship, just one point. In the pension regulation, it is specifically stated that after 4 years of retirement, no action can be taken. I can show you that.
Okay, Mr. Ganguly will not put that. Let it be like that only. Last part, we'll cancel that.
But otherwise, that option will be foreclosed. That is the difficulty. Because this will act as a res judicata, and the limitation is also there. Now, let that be there. He'll have his defense.
It's completely barred by the pension regulation. This is completely barred by the pension regulation.
That's a separate, that's a defense to be taken in trial. My friend wants.
Maybe, but see, that we found the deduction to be legal.
Recovery in accordance with law. Now, this your lordship has held is not in accordance with law. No, that does not foreclose the bank's option. Obviously, I cannot deduct his pension or
The pension regulation says that no, it's not possible.
Well, pension regulation, my lords, is regarding the provisional pension.
Not provisional.
Pension
All
regulation. That is a defense he can take in the trial. Now, if any, perhaps there will be nothing, but let that at least be stay on record, because otherwise, this is a statutory demand. A penalty has been paid by the bank from its own resources. For that, if they want to proceed, let them proceed. If it is maintainable, yes. If it is not, then only that antiseptic remark of your lordship will go a long way.
Lordship may kindly see page number 60 of the regulation, 46(2).
Read.
No departmental proceeding shall be initiated in respect of an event if more than 4 years time lapsed after the event.
I'm not saying about a departmental proceeding. Departmental proceeding after retirement now cannot be initiated. That is a law laid down even by the apex court. I am saying that if the bank, for example, wants to file a civil suit, a money suit tomorrow, can any law debar that? But this may be taken as a defense in that manner, that it's a barred by limitation, or it was decided, this issue has been decided by the Honorable High Court. Only in that option must be kept open. I cannot be left remediless. That is the only issue. Lordship has given him the relief that is entitled to, rightfully so. But if I want to recover that money,
but you still have a remedy also.
No other remedy. I can only go to civil court. That is the only remedy. If I go there, that option may be not foreclosed, and he will have his defense, if any. I have severe doubt that the bank will even proceed, but let that option be not foreclosed. Because otherwise, then it's a valuable public money. It's not somebody's individual money. And bank has not kept his 3,07,000 in its own pocket. Bank has paid it to the income tax.
Okay, then let it be there.
No, sure. Well, Mr. Sharma should be happy with what he has got.
Okay, next
Well,
matter.
I'm told me that item 27 was mentioned in the morning. Yeah, for the petitioner, otherwise there was an interim order,
Which item?
27. Order item. Without informing us, that has been done. So,
There was an interim order.
yeah, there is an interim order.
Okay, we'll take care of that.
Lodge. That may be extended.
Item 27, huh? Just check. Might have signed it also. Interim order passed earlier to continue till the next date. Item 27.
Keep that.
Yeah, your lordship.
Yes.
Lordship, this is the third round. Lordship, the petitioner before lordship is a serving member of the CRPF. She is a 50. Well, the respondent authority, the CRPF, are trying to transfer me out, my lords. I am a caregiver of my mother, who is a 79 years old lady, my lords, who is has a benchmark disability of 50% and covered by the Act of 2016, my right of person disabilities Act, my lords.
Regarding transfer,
Yes, my lords. Yes.
where are you now?
Right now I'm in Gauhati, my lords. Gauhati Group
There's
Center.
a stay order.
There's a stay order in operation, my lords. Kindly, that act lordship will take, my lords. And there's a standing order by the ministry, competent ministry, my lords, that such persons who are the sole caregiver, my lords, may be exempted from such kind of transfers. Now, my lord, I am in Gauhati. They are trying to transfer me out to, my lords, West Bengal. West Bengal, my lords.
It's a transferable post.
I understand, my lords, but the lordship will kindly have the act first, my lords. 16. Section 2R. The things went to that extent, my lord, I had applied for VRS to take care of my mother, my lords. Then, my lord, due to financial burdens, I have a EMI and I have to take care of my mother also. Section 2R, my lords. My lord, that 2016 Act, my lords.
There's no 2R here. 2016.
My lord, in many courts, that book is not, lordship is having the other Act, my lords.
49.
No, my lord, it is replaced by 16 Act. Person with Disabilities Act 2016.
Oh, person with disability.
Yes, my lords.
Not CRPF.
No, my lord. So Rights of Person with Disabilities Act 2016.
It is 1995.
16 Act. My lord.
16 is required.
I'll bring it, my lord, if I'll fix it up after post lunch, I'll bring the book, my lord, because I have a soft copy out.
Take a printout.
No, I have to, I'll bring the hard copy, my lord. I'll bring the book. At 2011.
By the way, what is there in that 2R?
2R, my lords, there is a schedule mentioned, my lords. 2R says a person, my lord, 2R reads as follows, if I may read, my lords. Person with benchmark disability means a person with not less than 40% of a specified disability, where specified disability has not been defined in measurable terms, and includes a person with disability where specified disability has been defined in the measurable terms as certified by certified authority. My lord, the mother of the petitioner.
Who is disabled?
Mother of the petitioner. Mother. So there are guidelines, my lords. There are guidelines formulated by the Ministry, my lords, of Home Affairs.
If one of your family member has this 2R difficulty,
yes, my lords,
you cannot be transferred.
Yes, there's a notification to that effect, my lords. I have annexed my
like that.
my lords. There's a policy, my lords. My lords will kindly come to page 74 of the petition. Page 74. It's a Ministry of Personal Public Grievances and Pension, my lords. page 74. Lordship has found, my lord, point 3 therein, my lords. Point 3,
Yes.
sub 1.
Yes.
With the enactment of the so-and-so Act on April so-and-so, the following instructions are issued in supervision of the above mentioned OMs of even number so-and-so, of November so-and-so, and January so-and-so, with regard to eligibility of seeking exemption from routine exercise of rotation/rotational transfer. Number 1, my lords, a government employee who is the caregiver of a dependent daughter, son, parent, spouse, brother, sister with specified disability certified by the certifying authority as a person with benchmark disability as defined as so-and-so may be exempted from routine exercise of rotational transfer subject to administrative constraints, my lords. Also, my lords, the second term, my lords, the term specified disability as defined in schedule to the right of persons with disabilities Act 2016 covers locomotor disability, including leprosy cured person, cerebral palsy, dwarfism, muscular dystrophy, acid attack victim, blindness, low vision, deafness, hard of hearing, speech or language disabilities, intellectual disability, including specific learning disabilities, and autism spectrum disorder. Number 8, my mother falls under this, mental illness. May be notified, the term specified disabilities as defined herein is applicable only for the purpose of seeking exemption from routine transfer or rotational transfer by a central government employee who is the caregiver, the dependent daughter, son, parent, spouse, brother, sister, as stated in para 3(1) above. And then my lordship has found it. And then going to Annexure 22, page 76. This is again my lords office memorandum, OM, my lords. These are guidelines, my lords, guidelines for providing certain facilities in respect of persons with disabilities who are already employed in the government for efficient performance of their duties. My lord, kindly come to page 78. Lordship will find the I, Roman, bold I.
Parents.
Exemption from routine exercise of transfer/rotational transfer in respect of government employee who is a caregiver of person with disability dependence. 1 there in my lords.
In your case, it's mother.
Mother, my lords.
Who else is there in the family?
No, my lords, only I am there. The petitioner is there, she's unmarried, she looks after the mother. I had been following, my lord, even the petitioner is of age 57 now. My lord, she had been following the transfer orders all along, but from 18, my lords, this illness of the mother, my lord,
Petitioner is a lady.
Lady, my lords.
So have you not approached them, authorities, that this is the provision?
Yes, my lords. In fact, I had represented before them that they had rejected my representation, devoid of any. There was no sympathy, my lords. Nothing.
Where
Even
is that rejection?
my lords will find a rejection. Lords, you will find at page 71. Pursuant to Honorable Court's order, my lords. Annexure 20, page 71. Seventy-one, my lords.
This is pursuant to the court's order.
Yes, my lord. There was a court order, my
This
lord.
is the second round,
This is the third round, my lord.
third round.
Third round. First round, my lord, when I approached, my lord, they cancelled the transfer order. Lordship will find, in fact, they mention at page 72 that my mother is suffering from so and so.
This order has been passed in terms of the which writ petition?
My lords will find that writ petition. Lordship will find at 1239. My lords will find
1, 2, 3.
39. Lordship will find, my lords. This is page 60, my lord. Annexure 18. There was a disposal order, my lords. There was an interim, my lords, and then the petitioners, the respondents
By this impugn order of transfer, you are not only transferred, but you also promoted.
promoted, my lords.
To what rank?
ASI.
Yes.
I was a constable, my lord, head constable, then an ASI, my lords.
So what will happen to your promotion if you don't go for transfer?
Promotion, my lords, to that effect, my lords, if I am so eligible, my lords, they can accommodate me somewhere nearby, my lords, where I can get the medical facilities with, along with my mother, they are being bag and baggage, they are sending me to West Bengal. I am agreeable to that proposition also, that they will post me around somewhere Gauhati or in Assam. Even that also, my lords. Even then also, my lord, there is a, if lordship takes up, my lord, there is a judgment, my lords, which report.
The condition of promotion is transfer.
And that they have to clarify, my lord,
After
because
transfer-
every promotion has not to be visited by transfer, my lords. That is very clear. Promotion is my due, my lords, because I have done good job, so I am being rewarded. But in the lieu of that reward, my lords, at the transfer, promotion as a shield, my lords, they are trying to transfer me out, my lords.
Okay, your case is that your mother has mental illness.
Yes, my lords.
What is the document to that effect?
Document, I'll come, my lords.
Is it page 80?
Last will kindly come to page 45. Otherwise, others are report, my lord. This is a conclusive, my lords, disability, my lords. Page 45, Annexure 11.
Issued by?
Issued by a professor and head of psychiatry, my lords. This is also a document. And then lordship will find it Annexure 12, page 47.
Moderate disability.
50%. Then lordship will kindly come to page 47. This is issued by Department of Empowerment of Persons with Disabilities, Ministry of Social Justice and Empowerment, my lords.
Page?
Page 47.
Which
This is
the
a this is a certificate, my lords.
Okay.
Then, my lords, Government of India issues a unique disability card, my lords, ID card. Lords will find that page 51. This is a certificate issued by Government of India, my lords. Unique disability ID. Mother's name is Rajni Prabha Devi. Mental type, disability type, mental illness, percentage is 50%.
This 47 and 51
51, my lords.
they are linked together.
45 is one document, my lord. That's a certificate of disability issued by the medical college. And my lord, 47 is also, yes, my lord, it's the ministry is the same, my lord.
No, 47 and 51 are linked to each other
Yes, my lord, linked, my lord.
by the ministry.
By the ministry, my lord. Authority is Government of India, my lord.
This is a receipt only.
My lords, which one?
Page 47 is a receipt. Receipt of enrollment.
My lords. My lords, these are not mechanical, my lords. I had offered myself, showed these documents, medical documents, then they said, my lord, that I have this disability, my lords. It's signed by senior medical officer, Joint Director of Health Science, my lords. And in fact, my lords, there's a,
No, Annexure 12 does not say that you are disabled. It's just a receipt.
it's a receipt, my lord, but there's a few lines, my lord. Requires disability person is 50%. Moderate mental illness requires reassessment after 5 years. Affected part is brain. Then again, if my lord, may I harp upon my lord, Annexure 13, page 48.
Page 38.
My lord,
Page 38.
48. No sane person will go to this kind of camps, my lord. And my lord,
All right, we'll come back.
at 2 months.
There was one matter at
Lord, I have inquired, but she didn't receive any appointment letter till today. So I instructed her to even take the instruction from the post office. She went there, so there is no appointment letter given to her till today. So, but as they have shown, the appointment letter has been issued. Lordship may keep it to the next week, then, my lord. Next Friday. Because the appointment letter shows that she has to join within 10th of August. So Monday is 10th of August. So if she couldn't receive that, so it will be difficult for her to join also.
Where is the place of joining?
It's as per they have shown place of joining is in Bongaigaon. And she is from Chirang district, another district.
July.
নাই পোৱা বুলি কৈছে। আপুনি নেক্সট উইকত ৰাখক, তেতিয়ালৈকে পাই যাব আৰু।
Like, কপিটো পোৱা নাই।
পোৱা নাই এপইণ্টমেণ্ট লেটাৰ এতিয়ালৈকে। আৰু জইন কৰিব কেতিয়া হ'ব? 10th of Augustৰ ভিতৰত জইন কৰিব দিছে, সেইখন মই চালো। সোমবাৰে 10th of August, নাপালে জইনো কৰিব নিদিব।
The copy of the order has not been marked to her.
On the date.
Not my lord, but I think in print out it was not reflected in but my mobile, my lord.
Just check.
Why don't know what I mean? Okay, okay.
Lordship may keep it and post it after, in the next week, my lord. In the next week, if she gets that, the lordship may close it. Because this order is non-compliance of 2015 order, my lord. So
In my most.
Smart. Serial number?
Serial number, my lord,
7.
9,
9.
9, my lord.
In the printed copy only up to
my
serial
lord.
number 6.
6, my lord. 7 is block elementary education officer. Then 8 treasury officer, Bongaigaon. 9 Ramzuli Busunta.
Please write Mr. B. Talukdar, Learned Standing Council, Elementary Education Department, by producing order dated 30/7/2026, issued by the Director, Elementary Education, submits that the petitioner has been given the appointment to a grade 4 post in the office of the Deputy Inspector of Schools, North Salmara, Bongaigaon. Vice Swapna Biswas. Mr. B.M. Deka, Learned Counsel for the petitioner, on the other hand, submits that on inquiry from the petitioner herself, she has informed him that she has not yet received a copy of the state order. Stop considering. No, stop, okay. Then Mr. B. Talukdar, Learned Standing Counsel, submits that a copy of the order has been marked to the petitioner. That's serial number 9 of the said order. Next, para, considering the above, the matter be listed again when? Wednesday?
next Friday, my lord.
Friday. Friday will be what?
14th. I think.
This is the matter again on 14th of August 2026.
Post office গৈছে পোৱা নাই। Much obliged. I have provided the book. Two are.
Not less than 40%.
It's 40%. 40% is the
50
benchmark of 50.
Your mother is 50%.
50, my lords. And then what is pertinent is, my lord, lordship will find they are in ZC. It speaks of a schedule. Schedule, my lord, there's a schedule appended there to me.
Where in the last part or where?
The
Schedule.
first, last part, my lords. There's a schedule. Immediately after repeal and saving, my lords. 102 is repeal and saving. Lordship has found that schedule.
Schedule.
Yes.
Yes.
Schedule, what you will find there's a sub category, it's called, it starts from schedule, in schedule. 1. 3 miles, mental behavior.
Yes.
So my case is, my lord, the issue, the medical illness, ailment which I'm suffering from comes from this, which the petitioner's mother is suffering from it. So since there's already 2 provisions I have, my lord, indicated, my lords, that it exempts me being a caregiver of a person who has this disability with the benchmark. Here in the qualifying benchmark is 40, mine is 50%. And regarding that question put forth to my learned senior friend, my lords, that is transfer as a prerequisite when it's promotion. Lordship, I have a small citation. This is reported 2019 4 GLT 976. In fact, it pertains to that Assam Gramin Vikas Bank. Lordship was hearing that matter. Lordship, at para 4, just do this observation. That's a small observation. It somehow fits my case, my lord, because in this case also, in the first round of litigation, the petitioner was transferred and the authorities were given the direction to this with sympathy to consider his my lord, his case. The authorities, my lord, the respondent authorities transferred him, though they passed an order, they said there is a element of sympathy, but the court found, my lord, there was no sympathy. In my case also, my lord, in the earlier round, I came.
Para 29 derivatives. From para 29. The findings of the court.
Yes.
29 minutes. Shall I read or?
Please read.
On consideration of the pleadings and submissions advanced on behalf of the bank authorities, nothing is ascertainable that the request of the petitioner for posting at Nalbari or nearby place has been considered by the bank authorities sympathetically. Sympathy is an attribute which cannot be assessed in measurable terms. It is a quality and state of mind which essentially lies within the person who takes the action or decision, which is not visible to outsiders. Therefore, the only way to ascertain whether a person has adopted a sympathetic approach can be ascertained from the effect such a decision or action has taken on the person from whom such decision was taken. Mitigating or lessening the hardship of the petitioner, such consideration would certainly be considered to be sympathetic or not otherwise. Therefore, merely in absence of any blaming effect by the decision taken, merely using the expression sympathetically considered by the bank authorities means nothing to the petitioner. Next paragraph, as mentioned above, consideration by the bank authorities has not helped the petitioner in any manner whatsoever. Rather, it has the effect of increasing the hardship and inconvenience of the petitioner to deal with a situation which is beyond his control. The fact that the petitioner's wife is suffering from serious head injury and resultant medical condition is totally beyond his control. So is the medical condition of his son, of which he cannot do anything except by taking care. In such circumstances, the only sympathetic consideration could be done by the bank authorities was to place the petitioner either at his hometown or to nearby place, which would not involve long travel times, so that he can take care of his ailing wife and son, thus to mitigate his hardships. Then, my lord, that question comes, my lord, that transfer that 33 minutes. It is now well settled that transfer policies do not have statutory force but are merely guided administration. As such, no employee has a vested right to claim posting on basis of a transfer policy, and the courts do not enforce such transfer policy in favor of any employee, such policy being non-enforceable. 34 minutes. If that is the judicial approach as regards transfer policy, it cannot be also stand of the authorities that they cannot deviate from the transfer policy, as it merely contains the guidelines for efficient and effective administration. Nothing prevents the authorities from adopting a particular approach for effective and efficient administration, even it is purely in terms of the transfer policy, so long it is not discriminatory or arbitrary. It is in this context, the principles contained in Article 14 of the Constitution of India come into play. Article 14 also mandates that unequals cannot be treated equally, and any action taken by authorities must be fair and reasonable. Thus, if the petitioners are able to make out a case that he constitutes a class of his own and cannot be treated in the same manner as other employees who do not have such medical issues to deal with, and if authorities accordingly on the basis of such consideration deviates from the transfer policy, this court is of the view that on the ground of departure from transfer policy, such an action of the bank could be said to be vitiated. Ultimately, it is the welfare of the organization as well as the individual which have to be balanced by the authorities concerned. In my case also, my lords, 35, seen from the above perspective, if the authorities do not dispute genuineness of the problem faced by the petitioners as regards the medical issues of his wife as well as son, this court is of the view that deviating from normal transfer policy cannot be considered to be arbitrary or discriminatory on the part of the authorities. Perhaps it is the concern of the effects of deviation from transfer policy that compel authorities to insist on following transfer policy to transfer the petitioner away from his home district to another region, irrespective of the consequences it may have on the petitioner. And then the question of promotion question comes now. The para 36 minutes. In this connection, one may also note that the bank authorities have taken the stand that the promotion to a higher post would entail transfer to a different region. Promotion is given to an employee for the efficient loyal service rendered by an employee as a recognition of their meritorious service. In other words, promotion is the reward for serving the establishment with sincerity and efficiently. If the stand of the bank authority is to be accepted, that if the petitioner had not sought for promotion, he would have remained in the original place of posting. Somehow betrays the lack of concern for the welfare of the employees, which also amount to non-recognition of the loyal, sincere service rendered by an employee, and would act as this incentive for efficient service. And then, 38, in the present case, even if the petitioner applied for promotion, fact remains authorities acknowledge meritorious service on the basis of promotion, he was given promotion. After this, after this, 41, this court is of the view that nobody would have any grievance if the petitioner who is facing serious hardship is detained in his hometown or in nearby vicinity, so that he may not have to compromise the quality of attention required to be given to his wife and his son. It may also be mentioned that nothing has been brought on record that retention of the petitioner in his home district would create any administrative problem, or his posting in home district would be undesirable. The only stand taken by authorities that there is no vacancy available at the present in the Nalbari region, and the petitioner had to be transferred out to other region upon his promotion. After discussing all these aspects, as mentioned above, this court is of the view that a case has been made out by the petitioner for interference by this court. Matter relating to posting is normally within the exclusive domain of the employer concerned, and ordinarily the court doesn't pass any specific order for posting employee to any particular place. In the present case, my lord, what is seen that upon bringing forth his grievances before this court on earlier occasion, considering the peculiar problems faced by the petitioner, directed the authorities for the sympathetic consideration of his representation for posting in his home district. Unfortunately, that has not been done. Therefore, my lords, this court is not inclined to give any option to the authorities, considering the peculiar facts and circumstances of the case, and would direct the authorities to post the petitioner to a branch at his hometown at Nalbari or to a place nearest to his residence, so the petitioner can continue to look after his ailing wife and son. Bank authorities will issue the necessary posting order within a period of 1 month from the date of receipt of this certified copy of this order. In my case also, my lords, if I come back to the order sheet, my lords, at my lords, which starts at page 60, Annex 18. Page 63, my lords, that paragraph in middle part, it's operative part, my lords. I was willing to forego this promotion also for the sake of my mother, my lords. And being served, my lord, this order of the Honorable Court was passed, my lords. I prefer the representation at page 68. At page 73, my lords, that order culminates into a page 71, it starts after my representation, my lords. The authorities, the DIG of the CRPF at page 73, these culminates, my lord. They reject, my lord, everything. Whereas at page 72, they discuss my mother's issue also.
How is that issue being dealt with?
My lord's mother's issue. My lord's,
Yes.
no, it only finds a passing mention, my lord, but lordship will see at page 73. There's no whisper about it. These lines which start. Is hereby rejected at page penultimate paragraph. In view of the above representation dated so and so, nothing, my lord, they have not dealt with this aspect. Just for the sake of mentioning, my lord, they mentioned it.
Come to your representation. Second para you mentioned,
My lord, which page?
page 68,
68, my lord, yes.
second para.
My lord. Specific line lordship is indicated.
Your representation, you have mentioned in the second para,
Yes, my lord.
I had challenged so and so on the ground that my 17th mother so and so.
My lord.
Then anywhere else you mentioned?
Again in my page, second page, my lord, page 69.
Third para.
Third para, my lord, third paragraph. And again, the page 70, my lord, second para.
And in the court's order,
Lordship will find the court's order at page 60. It starts at 60. The operative part, my lord, facts are enumerated in page 61 and 62. And page 63 is the, my lord's, operative part, my lords. 63, second para. The premises upon which the consideration was to be, my lord, scrutinized was set forth, my lord, through this paragraph. Court took the notice of the policy which was in existence till date, my lords.
you could take your mother to West Bengal.
My lord,
Could take your mother to West Bengal. Since only two of you are there, isn't it?
my lords.
Can take her there.
My lord, taking her there will be
Which
difficult. my
place
lords.
in West
And my-
Bengal?
West Bengal is an Naxalite affected area, my lords. That Durgapur somewhere.
Where?
Transfer order, lordship will find. Mm, Page 55, my lords. 56, my lord. I am at 1810.
65.
56. 56.
Serial number?
1810.
Where's this place?
West
232 M.
West Bengal, my lords.
232 M.
32. Durgapur বা কোট আছে? It's West Bengal. It shows minus some. It's a Mahila battalion, my lords, located in Pachim Medinipur district, my lords. Yeah. And range is Durgapur.
So it's not that you should leave your mother behind. You can take her.
my lord, taking her, my lord, is a difficulty which I face, my lord, because she becomes aggressive and she cannot withstand such a long journey, my lord. That is the issue out there, my lord. Even I applied for VRS also, but due to my that economic, my lord, financial fiscal issues, I need to take care of her also. I have my loans also. So I had to, I'm ready to forgo that promotion also. If that be so, my lord, that if I'm being promoted, I have to be sent.
The order says you have already joined, so there's no question of foregoing a promotion.
My lord, no, I'm still here, my lord. Interim is in operation. I'm still in Gauhati,
No, join, I mean your promotional post.
my lords. My lord, they have accommodated me here in that same rank in Gauhati, my lords. That I have particularly dealt with in my affidavit in reply.
Thing is that you are in a uniform force.
My lords, I understand, my lords.
So if you get a promotion, then you'll be having an additional. So this makes a difference. As a civilian, nobody notices.
My lords.
A person is in plain clothes. Promotion.
Promotion.
Unless you show the promotion order, nobody knows what is what.
My lords.
In your case, you are wearing uniform. After wearing that 3 stripes, you're putting a star here, 2 star here. And to take it off again,
Well, they have
It'll be-
come with a particular stand that there's no vacancy. One of the
anyway, the impugn order says that, what does it say?
my lord, 73, if it indicates, my lord, I have not been relieved. There's a direction to relieve me. I'm still serving here in Gauhati. In view of the
No, I'm not on that. I'm saying that whether I'm ready to forego my promotion to stay back and care. No. Yes, our request to forego promotion and to stay back at GC Gauhati cannot be considered as she has already taken over the promoted post on 10/2/2025. And she has already completed 5 years, 10 months at GC Gauhati.
my lords. Group center, my lord, that's group center. But that other part, my lords, the at para 7, my lord, I'm still serving. I'm still in Gauhati.
Decision has been taken on the appropriate level. DIG establishment.
Now, my lord,
So
I'm not
whether
asking
to-
sit a cancellation, my lord.
Whether to have that bargain, whether I'll stay back,
No, my lord,
take away
if
my
they can,
promotion, that may not be possible.
I understand, my lord, but now given the specific, my lord, these OMs, my lords, of the at page 74, and then at page 76, which says, my lord, that personal disabilities or caregivers should be exempted.
Anyway, what have they said? They have filed a response.
They have filed response, my lords.
What do they say?
They come with the same ploy, my lords, that the same answer that you have to go, that I have served here, my lords, for a long time. I have no merit in my case, and my lord, it's promotion, so I have to go. Sum and substance of their response.
It should be.
They even, my lord, at page 93 of the affidavit, and they even dispute that that medical condition of my mother. There's a standing order by the CRPF, my lord, retention of Page 93, Lordship will see. Then they.
Your representation was directed to whom? The DG. He is the highest authority, isn't
To the
it?
highest authority, my lords, to the DG. I don't know to go to that arguments, my lord, because it was addressed to the DG. DG should have been. I don't that argument. I'm not making, my lords. I addressed the DG. DG should have dealt with my representation. Though there is a line of argument, I'm not going to do that, my lords. Now, my lords, I'm not asking of simplicity, my lord. I know this is the part of my service conditions. I'm willing to go out, my lords, but if in the vicinity of Gauhati or somewhere where my mother's getting treatment in Gauhati, in vicinity of Gauhati, if there's any some kind of vacancy, if they can accommodate me, my lords.
Where are you now?
In
Same
Gauhati,
place?
my lords. Gauhati.
Same place.
Same place. 9 mile, my lords. 9 mile, my lords. The Jurabad side. The group centers there.
Before your promotion, you were there only.
Yes, my lords. I was there only.
So after promotion also, you were there only.
Yes, my lord, because all litigations were going on, my lords.
There was some stay order.
Yes, my lords, they were stay. In fact, in this case, my lords, an interim, my lords. Interim is in not to give effect, my lords.
I see. There's an interim of staying, staying the order of 13 May.
My lords, the first order, perhaps, my lords.
Yes, Mr. CGC, what do you
Yes,
say?
My lord, now he has given undertaking to and willing to go anywhere, my lord. Because of the pendency of this case and because of interim order, the authority has not could not taken any action. My lord,
No, you are just saying he is willing to go anywhere. Who's willing to go? Petitioner?
my lord, here she has applied for voluntary retirement. And that was accepted by the authority. And thereafter, he submitted an application that I have solved all the family problems and now I am willing to go. If the authority cancel my voluntary retirement, if the authority recall the order of voluntary retirement.
How do you say that?
Additional affidavit, my lord. Yes, each and every time, my lord, we have considered her case. And first, he has come before this court with a pair to retain her for another 1 year. And that was considered. And thereafter, my lord, after accepting the he was given permission by common order. Then he accepted the permission and declined to go on permission to West Bengal. And thereafter, my lord, this court, during the proceedings of the case, the second case, 2928 to 24, then he submitted that I want to forego my permission. And accordingly, this honorable court directed the authority directed her to submit a representation before the court or before the authority that that the petitioner want to forgo the omission. And submitted accordingly, this honorable court also granted interim till the issue of speaking order. And thereafter, the speaking order, that is the impugn order hereof, was passed. And thereafter, see, again approached this honorable court for this instance writ petition. And during this period, my lord, that normal tenure is 3 years. Now he has crossed the 7 years. And at page, my lord, of my additional affidavit. 112.
Additional affidavit,
Additional affidavit
112.
112. This is our application, this is the constructed copy.
Yes.
Subject application, that is the two Deputy Inspector General of Police, Group Center, CRPF Gauhati. Proportional application for taking voluntary retirement from service. With due respect, I number one so and so Maloti Devi said that I was enlisted in CRPF on such and such 97. I have completed 28 years of 8 months and 3 days as on such and such date. Applicant wants to proceed on voluntary retirement with effect from 39/2020 willingly for taking care of my mother. Hence, it is my humble request to kindly accord approval for voluntary retirement of the applicant with effect from such and such. Accordingly, my lord, in response to that, and that order 114. This is issued by the Office of the DRG Group Center, CRPF Gauhati. Office order. In accordance with the provision contained in Rule 48A of the Civil Service, Central Civil Service Pension Rule 1972 and Rule 43 of the Central Civil Service Pension Rule retirement submitted by the Post Number Assistant Sub Inspector Maloti Devi of this group center on such and such is hereby accepted and she is granted permission to take voluntary retirement with effect from such and such form. The qualification service of the personnel has been verified under latest such and such, on the basis of which office order dated 16/7/2000 was issued by Group Center Gauhati. According to the office order, the personnel has completed a total net qualification.
It's okay, you don't have to read the entire thing, CGC.
That
What has happened now? See, thing is that she has again filed this, she has filed this writ petition on 20th of May. What you have read was an application filed on 13 June. Order passed by the DIG on 25th of June.
Yeah.
But this writ petition was filed on 20th of May. Now, what has happened now?
Now, my lord, struck from the, that is the third
Struck off.
prayer.
No,
Struck off.
not
Struck
struck off.
off
It has been taken.
from the
That order has been taken.
with effect from 13/9/2020.
Hmm.
Then thereafter submitted an application, another application.
What is all this? You,
The another
you-
117 mile.
you file writ petition, then you also file the resignation. Voluntary retirement.
My lord, thereafter he submitted another application, my lord,
For what? To recall.
to recall.
Then what was happened? What happened then?
Then at para 4, at para 4, that another is that we have
If my transfer order comes, I will
settled
proceed on
orders.
transfer. She's given undertaking. So
if my transfer order comes, I will proceed on transfer. That is 4.
Then
we cancel the year, voluntary retirement,
you cancel the voluntary, by which order?
voluntary retirement
By
order.
which order?
That,
120, 190,
119, my lord.
119
119.
is hereby cancelled.
Yes,
Then
cancel. Now he is working, he is serving here. But because of interim order, we cannot take action. After
so you're
cancelling
ready
the-
to go anywhere?
No, well, condition is that since I'm not pressing that, I'm asking that not simplicity, my lord, I'm asking, my lord, since considering those OMs and this act, my lord, 16 act, considering my mother's issue, my lord, I might be placed somewhere in Gauhati, not in Gauhati specifically, but somewhere where medical issues are, medical is available, my lord, since my mother is undergoing treatment. That's my simple play, my lord.
That is for them to decide. You
No,
know,
no,
the very,
earlier my lords also, they have said they will consider sympathetically. They didn't consider, my lords. There's no whisper anything. When the court passes an order that you do this that way.
Now she is
They don't
bound
consider
by the
anything.
undertaking, my lord.
No,
She is
she's
bound
a
by the
person, my lord, can write anything, but can it be can it go contrary to the law, my lords? The duress under which she filed a VRS and the very predicament which she had to take back.
no,
That has
whatever it may be, you filed your voluntary retirement.
My lords.
Later on, you withdrew.
Yes, because of
They
the,
accepted it.
yes,
And you had said that I'm ready to go transfer on
yes,
transfer.
yes.
You cannot bargain like that. Now
I'm
you
not
say that
bargaining,
give
my
me,
lords.
give
I'm
me
not
somewhere
bargaining, my lords.
nearby.
Well, I'm not bargaining. Though petitioner is the at front, my lord, the mother is actually before the court. Because, my lords, the mother, I have demonstrated, my lord, she has 50% disability. That is not under dispute also.
No, don't bring your mother every time like that. You see, they have also taken care of that issue. That you are going to Durgapur or that place where there's a good place where you can give a treatment to your mother also. Both of you can proceed there. You have overstayed your tenure in Gauhati.
That I understand, my lords.
So that is why you join the service saying that I am liable to be transferred anywhere in India. Yes, you give your signature. What is the force you are working in? Your Central Reserve Police
CRPF,
Force.
yes.
This is not Guwahati Reserve Police Force.
My lords, I
This is
understand.
central.
Yes,
You
my
can
lords.
go anywhere in India.
But, my lord, the
So they have also taken into account your mother's plight, and so many waters have flown. You also have said that if it's the situation, then I will take voluntary retirement.
my lords.
Then on a second thought, you say that I've got many loans, so if I resign or if I go on voluntary retirement, I'll suffer. So you take back, you say that please cancel that, and I'm ready to go anywhere.
My lords.
At the same time, you come to this court and say that there should be a stay of my transfer.
I'm not
What-
pressing, my lord,
my
that
lord,
they should
he-
cancel my transfer,
in the-
but if they can modify, my lords, considering my mother's issue.
We stated in our application, my lord, petition to recall the voluntary retirement that I have solved the problem. How he solved, but he has some monetary problem, financial problem. We considered it.
Is there any prayer anywhere in your
And this
petition
honorable court may direct
saying
the
that
authority.
you may be posted in lieu of West Bengal, I may go somewhere nearby?
But in a good place, having a
No, that is from the,
Yeah, but
my lord,
this
they are
may-
just, there's the averment, my lord, because on earlier occasion also averments were made that they will sympathetically consider, my lords. The order which I have challenged, my lord, I have indicated they have shown any, no sympathy, nothing.
So tell me what is to be done.
Well, if they can accommodate me, my lord, somewhere in Assam, my lord.
CGC, can you take instructions in this regard?
My lord, in Assam, my lord, there is no place of posting and no vacancy.
That he has to say from instructions, he cannot say from his
And the
own, my
court
lords.
may direct the authority to send him, to transfer him to a place where hospital, medical facilities are available.
Durgapur, it's available.
Yes, my lord.
What kind of facilities, my lord, they have, I have to know, because I'm dealing with a special person, my lord.
See, you cannot.
That
bargain
I
like
understand,
that.
my lord. My limited prayer is
Is
that, my lord.
brought
If he
seven-
brings an instruction, my lord, if he brings a written instruction, what kind of facilities are
Against
available,
10 or
my lord,
3
some in Assam or nearby, if they can accommodate me, my lord, I'm willing to go.
Tenure is 3 years as per standing order, my lord. I have annexed it. in the affidavit. 3 years. And on promotion, it is compulsory to go anywhere. On promotion, it is not the normal promotion, my normal transfer. It is the promotional transfer.
Where is the promotion order?
Promotion order at
Transfer
page,
order, promotion order.
Promotion order, my lords, will find that,
page-
uh, 16.
page 55
55, my lords.
of read petition.
There's something wrong in this? Page 55,
My lord,
page 55, come to page 55,
yes,
second paragraph.
yes, as per service particulars.
Read.
As per service screening proceeding received from DPCs convened by the respective sectors, officials, panels of ACs, GD, ML, male and female, up to G list number such and such, a list on 1/7/2024, corrected up to 31/8/2024, have been prepared as per vacancy. As per vacancy, as on 1/1/25, the following 3033 SCGD male, female, held at serial number 1 to 3033 on panel I hereby release on promotion as SCGD.
Stop there. Released on promotion as head constable GD.
GD, my lord.
Promotion to from head constable to head constable, they are promoted. Is it not a promotion to SI?
SI, ASI.
So something wrong here.
My lord, he was the head constable first.
That is
Before
correct.
that.
That is correct. So promotion from head constable should be SI.
ASI.
It says on panel are hereby released on promotion as head constable GD. Same rank they are released.
No, my lord.
What?
No,
No,
my-
you read what you see what.
Promotion GD to ASI.
Released on promotion as head constable GD.
On promotion as ASI, last page, my last para, last line,
Before last para.
last line.
Yeah, last para is last para. I'm not reading last
Yes,
para. It is the
yes.
fourth line.
The AC permitting such and such, which will be effective from the date of their taking over the post of ASI.
You don't
GD.
understand what I'm saying. They are hereby released on promotion as head constable GD.
GD.
That is
And,
not the case. They are released on promotion to ASI. So there is a mistake here.
The DG CRPF conveys his heartiest congratulations and best wishes for their bright and successful career ahead on promotion as ASI GD. General duty, ASI general duty. They are posted to the unit officers as mentioned against each other. GD means general duty,
HC means
Head constable.
head constable.
not ASI, isn't it?
Yes.
So promotion to head constable, from head constable.
No, my lord, ASI.
This is what the order is saying.
Maybe why, yeah, but ASI, now he is, his rank is ASI.
So you take instructions. You take instructions. Whether some consideration can be done.
My lord, he was given, we have accepted her application. That he is, my lord, as per tenure, normal tenure is 3 years.
Mr. Counsel, please understand what I'm saying.
Yes.
Don't go back to the story again. 3 years, she has completed 7 years, she has been transferred on promotion. All that we know. Only one aspect is that whether she can be considered for transfer to any other place nearby, apart from Durgapur. Yes, good. If no, then we decide.
But as per my instruction, there is no post bath because there.
Oh, you already have the instruction.
Yes, my lord, I have taken instruction with that.
What
if
instruction?
If the authority, if the court direct the authority to transfer him any place where medical facilities is there, that we can expect. But in Assam, there is no such battalion in CRPF.
There's no battalion in Assam.
Group center, in this group, under this group center.
Group center. 9 Mile is the only place where you find CRPF in Assam.
No,
My lord, I will take the instruction.
Dimapur there is there, Karbi Anglong there is there, Khotkhoti, my lords, there are a lot of group centers.
My lord, I will take the instruction.
When can you take the instructions?
That any day next week, my lord.
Next week.
Next week. Any date may be fixed, my lord. Vacancy must be there.
That you will find out.
Yes.
Court cannot say vacancies there, go there. It is for you to tell us. If there's no vacancy, tell us there's no vacancy. If there is vacancy, tell us where's the vacancy.
Yes.
So that's why I'm giving you time to take instructions. So today is what? Today is
7th.
7.
Today's 7th. Today's 6 or 6 man. 6.
Today is tomorrow.
No man, 6.
Then
Today's
today is 6.
6.
Next week.
Next week 13. 1 week.
One.
List again on 13 August 2026.
Fine.
To enable Mr. A.K. Datta, learned CGC, to obtain instructions as to whether the petitioner can be accommodated, whether the petitioner can be transferred to any nearby places apart from what has been apart from her transfer to Durgapur, West Bengal.
That may be fixed.
This is 13.
13.
13 is a date. Again, you're saying date may be fixed. This is your book. Your book. No, why? If it's your book, you take it. You make a note. Make a requisition for that.
May please your lordship. Lordship, I have filed my affidavit today only, lordship. As I was unable to communicate with the council for the petitioner for last 1 week. So
You appear for which party?
I'm appearing for 2 to, lordship,
Huh?
2 to 6, lordship. Anyway.
Animal husbandry.
Animal husbandry.
Standing council.
Standing council.
Have you served a copy?
Yes, lordship.
Yes.
So you want to go through it and file a reply?
Yes, sir.
Learned Standing Council, Animal Husbandry and Veterinary Department submits that she has filed the counter affidavit today and served a copy to the Learned Counsel for the petitioner. Learned Counsel for the petitioner prays that he may be given some time to go through the same and file a rejoinder affidavit if so advised. Accordingly, matter stands adjourned to be listed again. When?
So after 2 weeks.
2 weeks, after 2 weeks.
Obliged.
May it please, my lordship. My lordship, as per the last order of the court, order dated 23/3/2026, the respondent, NC Hills, particularly respondent number 4, 5, and 6 were supposed to file an affidavit, which they have not filed till the.
My lord, in fact, what has happened, we have prepared our affidavit, but in the meantime, there was a judgment passed in Supreme Court, my lord, which is now holding the field, Shukhendu Bhattacharya. So regarding that, my lord, government has not taken any decision as yet, and the appeal is also pending before the division bench, which was disposed of recently. Similar matters are also pending before the.
No, Supreme Court has decided what?
My lord, that the pension benefits and other benefits should be given to the master workers, my lord.
Master workers. And after that, division, it's pending before division bench.
Division bench, the matter, my lord, decision has not been taken by government. So until and unless government takes a call on this, how we are going to
So
proceed.
after Supreme Court takes a decision, what is there in the division bench?
My lord, I'm told that, my lord, recently there is some alteration also in that judgment. So I'm not very sure. So we have kept this matter on hold. I'm praying before your lordship that it may come up after 4 weeks. So that in the meantime, a policy is formulated how we are going to proceed with these matters, my lord. And here the petitioner, she has filed this petition at the, when she was at the age of 65. And she is seeking, my lord, her regular scale of pay was already granted, my lord. Now what she is seeking, my lord, here is
She is seeking confirmation of service.
pensionary benefits and all. So as
And
per that judgment, my
to
lord, she
treat
is
her as a
entitled.
permanent employee and to give her retirement benefits.
As per that judgment, because our judge affidavit was otherwise, but now because of this judgment, my lord, we cannot file that affidavit.
Your affidavit is not there.
No, my lord, we have not filed it. Ma'am. We prepared it, we send it for waiting, but in the meantime, this judgment has come. So we have
What is the judgment?
Shukhendu Bhattacharya, my lord.
Reference, give me the reference.
My lord.
You are appearing for which respondent?
Devasam.
Which respondent? You are for NC Hills.
My lord.
What is your name?
Peach approved.
No, counsel for the petition.
P. Yepto, appearing on behalf of P. Baura, my lordship.
PM
P. Yepto.
P. Aptho.
Yes, my lordship.
Miss P. Aptho.
Appearing on behalf of P. Baura.
Learned counsel appears on behalf of Mr.
B. Baura.
B. Barwa, counsel for the petitioner, and submits that the respondents have not yet filed their counter affidavit.
Okay, if I may, lordship. Lordship, if I may clarify, lordship, we are a necessary party and lordship, we have been made a party, but our names have not been reflected. And at the end of the day, lordship, final concurrence has to be given by the finance department. So lordship, we'll also file a affidavit in the matter.
You filed, nobody's
Lordship,
objecting.
our names may be reflected because we are.
Okay. Don't panic. I'm not disposing it now. Miss, your good name?
Peach approved.
P. Chakravarti, learned counsel, appearing for the NC Hills, submits that although affidavit in opposition was prepared and was sent for vetting, but in the meantime, the apex court has taken a decision in
Shukhendu Bhattacharya and others.
Shukhendu Bhattacharya and others.
In civil appeal number 4514 of 2025.
Have you written? Civil appeal number
4514 of 2025.
4514 of 2025, wherein masteral employees are also to be considered for being given pensionary benefits. The matter has to be re-examined again, since the government would have to take a policy, will have to take a decision in this regard. Will have to formulate a policy in this regard, in line with the decision of the apex court. Stop. She therefore submits that since this will take some time, she may be given 4 weeks' time to file the counter affidavit. Mr. A. Chaliha, Learned Standing Counsel, Finance Department, submits that since pension matters would involve the Finance Department, since the matter involves, since there is a financial implication in the matter, the finance is a necessary party, and an affidavit will have to be filed by the State Department, and for which he also prays for 4 weeks' time. Anybody else? Mr. C.K.S. Barua, Learned GSM, appears for the pension and public grievance department, and also prays for similar time to file the counter affidavit. In view of above, matter stands adjourned to be listed. To be listed again on 23rd of September 2026, showing the name of SC Finance in the cost list. The respondents to file their respective affidavit in a position in the meantime.
Obliged.
20, anybody?
Maybe Lordship, this matter relates to non-consideration of the service benefits which was rendered by the petitioner, and those after his retirement, these benefits are not given to him. This is a scheme modified, named MSCPS Modified Assured Career Progression Scheme. Under this scheme, Lordship, the person, if he is not promoted during the first 10 years within his service, then he will get one annual increment. And in 20 years, if he is not promoted, then he will get 2 increments. Kindly see Lordship, page 15, the annexer I have enclosed.
We have written to the Department for Instructions, but those are awaited. Lordship.
One more time. How much time?
3 weeks, Lordship.
Okay, on the request made by Learned Counsel. On the request made by Mr.
A.K. Ghosh.
A.K. Ghosh, Learned.
I'm appearing on behalf of Mr. K. Ku, an additional agent.
Counsel appearing on behalf of Mr.
K. Kumar.
K. Kumar, Learned Additional AG. Further 3 weeks' time is granted to receive instructions and to file counter affidavit.
On February also they took time, Lordship. Last February also they took time. That indication may be given.
Mr. You are Ghosh.
Lordship.
So you are Mr.
Ahmed.
Ahmed. What Ahmed?
27 to Lordship. It last, they have taken time.
You tell me your name, Mr.
What? No.
Yes, you Ahmed.
Yes,
Learned Counsel appears for the petition. 2026 matter. Let them take some more time.
May I please, your Lordship? Lordship, kindly adjourn the matter for the day. Engage Senior Counsel Mr. H.R.S. Chaudhary is out of station, Lordship.
Mr. H.R.A. Chaudhary.
My lord, would your lordship be pleased to see the second order, my lord, that is 19/9/2025, my lord. I have challenged the appointment of a Gauhati, which my learned friend is from the other side. But the till date they have not filed their affidavit, and affidavit in opposition, which is more than 1 year have passed. Your lordship may give them the time, but at the last chance of filing the affidavit, my lord, it is exactly more than 1 year.
When can you file?
Lordship,
See,
Lordship,
if you're
kindly allow 4 weeks time, Lordship.
19/9/2025, order is clearly there. They have taken time to file the affidavit 1 year back.
Is there any interim order?
No, my writ petition challenging their appointment.
Okay. Who are the respondents?
My lord, respondent state and respondent number 6 is the private.
You are challenging the appointment of respondent number 6.
Respondent number 6,
State has also not filed.
no, not filed.
Probably they are waiting for you only. Normally, private respondent waits. Let department reply, then I'll reply. If you don't reply, they will not reply. What's taking you so long?
I think the private respondent should have filed, because if the department doesn't file, still her appointment will go. If I succeed. So invariably, she should defend herself. And on the day of notice, they appeared through caveat. It is not that it was ex
Private
parte.
respondent is he, not she.
He, yes, ma'am.
Yes. You want some time?
Not.
When will you file?
The commissioner either at Pataman, he because the selection process is done by the deputy commissioner. Even then, not if it's prepared also, I will file. 3 weeks then.
Parties are represented by the respective councils. Let's wait for further 3 weeks' time is granted for filing counter affidavit. That's the last chance. List again after 3 weeks.
My lord, a date may kindly be given after 3 weeks.
Give a date also. Remaining matters, you'll get a date. I have to rise.
Yes. 8, 9. It's okay.
Oblige, Your Lordship.
It's almost 4 weeks. Yes, yes, yes. Yes, yes. I'm lucky that the matter has reached. I was thinking about 315. We are lucky in that sense, my lord.